Status of a woman as a member of ST does not change consequent upon her marriage to a person who is not a member of ST. The explanation under Regulation 3 of the regulations inserted by the Amendment Regulation 1976 is not clarificatory in nature. Rather, it introduces a substantive provision prohibiting transfer of an immovable property by a member of ST to a female member of ST after her marriage to a person who is not a member of ST. In the absence of any legislative intent to apply the said explanation retrospectively, the said regulation cannot be given retrospective effect. After having held so, we have dismissed the appeal. Self-correction. Signature data.
Obliged Lordship. I agree.
Yes.
Can I seek your kind indulgence? One matter which has been traveled to Honorable Apex Court. I'll just give you a copy of the Honorable Apex Court order. The matter is relating to opening of the telemedicine nodes by the entrepreneurs. Now the government has changed the policy decision. Now this Honorable Court has passed an interim order stating that they will continue with their nodes and there will no bar in opening the new nodes. Now subsequently, the state has traveled to Honorable Apex Court and they have vacated that interim order. This Honorable Court at paragraph 4 has been stated that this Honorable Court should take.
Why are you making a mention?
The difficulty is, Your Lordship, we have taken the loans from the bank, but because of the.
No, what do you want your case to be listed?
Your Lordship.
All right, give you. Who is for the other side?
The state is there, Your Lordship.
Your case is to be listed for the first time.
No, Your Lordship, it has already been listed, but because the Honorable Apex Court has stated that it has to be heard expeditiously and has to be disposed of, I have given that, Your Lordship. Yes. By the Chief Justice of this Honorable. At page number 4. Page number penultimate portion.
All right, we will take up this matter tomorrow under the heading to be mentioned. Okay.
I'm grateful.
For fixing a date of hearing.
My Lord, I'm grateful.
We mentioned item number 2. I am producing that
apologize. Item number 73. There is a professional college law examination matter. Lordship heard it and kept it for the response of the opposite party. It will not reach my lord. Tomorrow my victim application is there. Tomorrow in orders, I may be.
We will take up your matter tomorrow. Who is for the other side? Who is for the other side, madam?
My lord, that I have informed him. University, Mosudon Law University, my lord.
All right, we will take up your matter tomorrow. Please inform him.
My lord.
Item 67 and 76, the same matter. Mr. Mahanti is in one data application petition, Mr. Palit is one, I am in one. 76. The petition anytime after vacation at 2 o'clock, so that.
They have not yet served the counter, because they agreed that they will serve the counter before today. They have not, and I find from the list that your lordship has fixed certain matters after 2 o'clock. So,
Even otherwise, it is not likely to be taken up.
No, it is being taken up, but the
No.
matter, let them find, have a copy of the counter, so that if they will adopt the counter, they have filed this Palit's case.
if they adopt it
Choose to
also,
adopt
let
it.
them give a copy.
Same.
Then it
Item
will-
number?
76. 76, second item, sub-item 2. Counter has been filed by the state. So if they adopt it in.
Item 67.
We are just adjourning those matters. We are just adjourning those matters to any date which you suggest.
Any date that is convenient to us.
Convenient to your lordship.
After vacation, any day, because
Last week of June.
we don't want to burden your lordship before vacation, because there is some urgency. Yes, 26 at 2. Grateful. That's great.
No, may I pray under your lordship fixes it up at 2 o'clock?
Yes.
Yeah, that will
2 o'clock.
Small noting, like 2 o'clock.
Yes, yes.
Great, great.
Order करो.
Thereafter it has not been said. All, we are not saying another budget, but it will be.
All of us.
That's why I think Marot asked us to give the memo today. So I'm just giving the memo, all the back factors are there. They will be fixed that, because they give it to you, but they give their.
Pardon to mention, my lord. My lord, the matter was earlier before the single judge, my lord. Earlier, the matter was before saying single judge. Well, the single judge has directed the registry. The matter may be listed before the assigned bench on 20th February. Till then, no matter is not been listed.
Matter will be listed. The matters shall be listed. All right. Even if you don't make a mention, your matter will be. Make a brief salutation for the matter.
Publish.
Your Lordship, may I be pardoned to mention the matter not submitted before your Lordship board? To read application challenging the judgment of Honorable Single Judge regarding the
Did you file your appeal?
Yes, we,
When did you file?
no, sir, today only we will list the matter, yes, sir. Batch of connected matters has been fixed to tomorrow. So we request
So
your,
wait for those matters to be
Yes.
taken up first, then make a mention.
sir, we request your Lordships to listing the matter to tomorrow with the connected matters.
Cannot be done. You filed your appeal only yesterday and you want your matter.
Your Lordships, 960/2024,
Sorry,
that all are
no.
listed
Not now. Make a mention on Monday.
Monday. Okay, sir. Thank you, sir.
Item 2.
That we got this notification, Your Lordships, which clearly clarifies.
Whether that is there on record or
No,
not.
that is not their record. I think
Is the
Mr. Mahanti is
notification.
filing by way of memo.
Therefore, while they're dictating the judgment, I was trying to find out.
No, that's not on record.
That is not in
I'm
the
sorry, my lord, is the notification of the Indian Nursing
That
Council.
clearly, that clearly shows.
Madam, I am-
Mahanti filing the same by
By
memo.
memo.
Same memo.
I am filing a memo with the letter to accept it as an.
It's the same notification. That clearly says that all batches up to 31st October are regular and thereafter everything is irregular. The second paragraph says.
Yes. All right. Therefore, I was, I tried my best to
No, this
It is-
wasn't there.
It is my mistake, my lord. I should.
everyone's mistake.
Regular batch.
Test admission item number 3.
Government was supposed to file a counter
Item 3.
to your lordship's PIL 29 minutes, the settlement work, survey settlement work in and consolidation work in 29 villages have been stopped in the Jajpur division. Earlier, your lordship had also directed, page 41, the writ petition is accordingly disposed of and it is directed that the notification dated 24th May 2022 be worked out within a period of 4 months from today. That was your lordship's direction on 28/6/2022. Now, despite that, my lords, for some reason, the state government has not worked out the notification. And so therefore, we also,
No, you are selling what in this PIL?
my lords, the inaction on the part of the state government in working out its own notification as a result. My lords, no land transaction in 29 villages in Jajpur region is being able to be, my lords, transacted.
No, but that will be against law. That we cannot interfere with such decision of the government.
No, government has already said.
What?
Government has already said, your lordship may kindly come to the your lordship's order dated page 41. On 24th May 2022, government has already come out with a notification.
What?
My lords, that is at annexure 4, page 25 to 33, that they will conduct.
You have taken us to page 41. What is there in page
41, my lords, I was only alluding to your lordship's earlier direction in view of the subsequent development in which a fresh notification has been issued on 24th May 2022.
What is this notification?
This is at page 25, annexure 4.
What is this notification?
This notification is, my lords, that the, I'll just take 2 minutes to place the first paragraph. In exercise of the powers conferred under subsection 1 of section 3 of the Odisha Special Survey and Settlement Act, read with sub-rule 1 of rule 4 of the Odisha Special Survey and Settlement Rules 2012, the state government do hereby notify 204 number of villages of Jagatsinghpur, Jajpur, Kendrapada and Kalahandi district as a schedule for conduct of special survey and settlement and preparation of record of rights simultaneously with respect to all lands lying in the area comprised within the limits of the villages. So this notification, with the advent of this notification, my lords, the earlier PIL to conduct such a, my lords, exercise was not pressed, and my lords, and your lordships gave a direction that this notification be worked out within 4 months.
It's impossible. That cannot be done within 4 months. It's
No, it's already more than a year. More than a year.
It's a humongous exercise.
No, more than a year.
Let us see the law.
Much more than a year, my lords. Your lordship's direction was on 28/6/2022. Your lordship had directed. And in fact, this matter is being listed for the second time today. On the earlier occasion, your lordships had given them 8 months, 8 weeks. Probably my learned friend had sought for 8 weeks time to react to your lordships.
So have you seen the provisions? This is impossible for any government to work it out within 4 months.
No, not 4 months. Your lordship had directed as far back in 2022.
Yes, even 2 years. It will take years. It will take years, Mr. Palit. Just see the provisions.
No. This is a standard exercise. It's to be normal.
No. Just see. In fact, the records of rights are to be prepared afresh.
My lords.
So it's not easy. Not easy.
Whatever
That
period your
easy.
lordship grants, my lords. In fact,
It's like this Consolidation Act is very akin to that provision.
Just like. My lord, may I comment for now? My instruction is that there are 22 unsettled moujas under Danagati Tahsil. As per government notification number 16812 dated 24th May 2022, the special survey and settlement operation has been started in Danagati Tahsil, and gradually all 22 moujas will be covered under this operation. So it is already started, and gradually all the moujas will be covered.
with my learned friend's statement recorded, my lords,
Yes,
lordship may dispose.
this is the instruction.
My lords.
This writ application in the nature of public interest litigation has been filed to denotify. You want denotification?
Yes, it was notified to be acquired for NINL, Nilachal Ispat Nigam. Huge tracts of land were notified, but actually, my lord, the plant was set up over a limited portion, and the rest of the my lord's lands were it remained as such. So therefore, denotification has to happen. Those lands which were not eventually acquired.
No, but when was the notification issued?
My lord, that was 10 years, more than 10 years. This is.
What do you want in the present PIL?
Prayer is at page 13, my time. 13 of the rate.
Page 13.
Prayer is very limited.
Very limited minutes.
And to address that prayer, I have received the instruction which I have submitted with the lords.
Parties to take immediate necessary steps and action regarding settlement and consolidation work of 29 villages in the district of Jajpur.
Under Danagati Tahsil.
Danagati Tahsil.
Under
Danagati.
Under Danavadi Tahsil
In the district of Jajpur.
in the district of Jajpur. So it appears that where is the notification?
My lord, and I can.
Page 25. Page 25, annexure 4.
It appears that the government of Odisha in the Revenue and Disaster Management Department has issued a notification on 24/5/2022 in exercise of the powers conferred under subsection 1 of Section 3 of the Odisha Survey and Settlement Act 2012, read with Sub-Rule 1 of Rule 4 of Odisha Special Survey and Settlement Rules, comma, for conduct of
Special survey and settlement operation.
notifying 204 members of the villages of Jagat Singhpur of the districts Jagat Singhpur, Jajpur, Kendrapada and Kalahandi for conduct of special survey and settlement and preparation of record of rights simultaneously with respect to all lands lying in the areas comprised within the limits of the villages. Full stop. The petitioner, these petitioners had earlier filed or some
Earlier,
other?
same petitions.
These petitioners had earlier approached this court seeking similar relief.
Similarly,
Which page?
page 41. Earlier order.
Seeking similar relief. Giving rise to WPC bracketed PIL number 12266 of 2022. The said writ petition came to be disposed of with the following observation by an order dated 28/6/2022. Stop. Next. Senior counsel appearing on behalf of the petitioners has submitted that since the notification was issued in 2022, the work of survey and settlement / consolidation ought to have been carried out. He submits that the state government should denotify the said villages. Where is the provision of denotification?
My notes, there's the recommendation.
No, where is the provision for denotification? There must be provision. He submits that because of the said notification, the landholders are not in a position to enter into any transaction with their lands. Also, next one, additional government advocate has submitted
On instruction.
instructions that the work of survey and settlement has been started pursuant to the said notification.
Covering all the
Dated-
Moses, 22 Moses.
Dated so and so covering all the 22 Moses
Moses of Danagadi Tahsil.
Tanavati Tehsil of Jajpur district. Full stop. He submits that given the procedure prescribed under the Act for preparation of final records of rights, comma, completion of the comma, where is the provision for denotification? There must be.
Denotification is not.
They have to withdraw. They have to withdraw the
Where
notification
is that?
first.
Withdraw whatever you call it.
That is,
After the survey, the settlement operation will be completed and record of right will be published.
Published thereafter, the provision is, normally there is a provision under the Consolidation Act that the villages are denotified. Once the consolidation exercise is over in a village, that
That
village
is under
is
section 41, it will be denotified. And
under
here
section,
the section 12 and 13, I think, deals with that.
follow, see, all right. All right, thereafter consolidation will begin.
12B is the final publication of.
No,
record of
please come
rights.
to 13.
Preparation as to final publication and correction of record of rights.
Please come to section 13. Now, considering the
13(2).
section 13.
Yes.
So after this exercise is over, or
Yes.
this exercise shall be taken into account for the purpose of consolidation also.
Yes.
Please see section 13 of the Act.
Survey and Settlement Act.
Yes. Survey.
This special
My lord.
special service settlement. That section 13, that says consolidation to follow.
Thereafter, after the settlement is over, then it will follow. That is that their prayer is for publication of the settlement record of right.
Considering the submission advanced on behalf of the state based on instructions that the survey under the survey of lands in the said 22 villages has started, comma, this application is disposed of with an observation that let the authorities proceed as expeditiously as possible in the matter.
Item number 4.
grateful. May I please your lordship? Here, my lord, the petitioner has filed this contempt application for initiation against the district magistrate Khurda for
Where is the
not,
order?
my lord, page 9 is the order of this honorable court dated 14/3/2023, whereby this honorable court has directed para 3, my lord. In view of the above, this court disposes of this writ petition directing the opposite party number 2, Collector Khurda, to act upon the letter dated 9th March 2023 issued by Senior Administrative Officer and DD AIMS Bhubaneswar to make assessment of the compensation amount so that the benefit can be extended to the petitioner as expeditiously as possible, preferably within a period of 3 months from the date of production of the certified copy of this order, my lord.
Yes.
Thereafter, the petitioner submitted the order copy before
Yes,
the,
Mr.
but the
Lordship, I think it is for the first time, Lordship, next week only I can obtain instruction regarding compliance.
All right.
But-
Let it come after vacation.
Yes, Lordship.
my lord, next week, my lord, because I am landless, my lord.
All right, all. Next week. As requested on behalf of the contemners. Requested by me, so and so, on behalf of the contemners. List this matter on 1 week. So as to enable him to seek instructions. As to whether this court's order violation of which has been alleged in the present contempt application has been fully complied with or not.
Item number 5.
Yes, item number 5, Lordships on 10th of April, your lordship are pleased to grant me 6 weeks time to obtain instruction. So I try to contact your lordship, take it at 2 o'clock, contact the collector.
2 o'clock.
Item number 6.
Maybe.
Yes.
This case, my lord, I am challenging the order of the honorable single judge.
Where is that?
My lord, at page 86, annexure 14.
Yes.
Order starts with page 88. Only the point of law involved in this case is, my lord, whether under the order passed by the tribunal under section 24C, any order that says is applicable to this honorable court or not. This is the first. The second issue was a person who has no list or has say in the list filed by me in the tribunal against the government has any right to intervene. Because the tribunal has allowed the intervention petition. Because my case was, he was neither a necessary party nor a proper party. These are the only two basic points, man.
No, but you have, someone had intervened.
Yes, that was the objection raised by me.
That intervention application has been allowed.
Yes, against
So
that.
you are challenging that order.
Yes, ma'am.
That interim order.
Yes, ma'am.
The matter
That-
is still pending.
Matter is pending in the tribunal. This honorable court has interpreted the first before going to that intervention petition by referring to section 24C of the acts, that though this, and let me place the act first, my lord. The tribunal says no, it is permissible. No interlocutory order can be applicable. That is the finding of this honorable court in the single judge. I will kindly have a glance to section 24C. Because my application before the tribunal was under section 24B. That is the provision of law. That will page 161. 24B is page 159. 159, 24B, man. The power of the tribunal. Appeal is 24C.
So the provision is very clear.
24C, man. Yes, any order.
Yes.
But the tribunal says no, it is an interlocutor order. This honorable single judge has said this is an interlocutor order, so this is not maintainable. That is the finding. Kindly see, my lord, I will take to my lord that finding itself.
No, but this order was passed in first appeal.
Yes. This honorable court, honorable single judge, my lord, page 100, may kindly say only one line. He says no, this type of order, interlocutor order is not applicable under 24C. But my case is any order. Statute is very clear, man. That is my submission altogether. May I draw my lord's page 100? The finding, only last part of it, only one line.
Yes.
My lord, page 100, the first paragraph, last line. In this case, 5 lines from the first paragraph. In this case, the appellant challenges the order passed by the tribunal allowing the intervention application appears to be an order, to be an interlocutory order, and thereby no appeal would lie against such order. This is the finding. But the statute says any order. And many other benches of this honorable court has also allowed all such petitions where filing my lord interlocutory order, that is entertainable.
All right.
Right.
That is your one point.
This is first. And this is with regard to the merit of the case, whether he is a necessary party or proper party. My case is, I am an employee. The application was under section 24B. Section 24B says, if any dispute or arises between the employee and the state, my lord, 24B is there.
Yes.
Page 159 of that document.
Yes.
My lord, shall I read, my lord?
Yes.
My lord. 24B, adjudication by tribunal. The tribunal shall have jurisdiction, power, and authority to adjudicate all disputes and differences between the managing committee or as the case may be, the governing body of any private educational institution and any teacher or employee of such institution or the state government.
Yes. Why do you say that the intervention was not?
Intervener has no list. I have filed the case before the tribunal because the government on some allegation that directed that withdrawal of my grantinate. So this was the dispute. So I filed the case against the tribunal, against these government officers in the tribunal, against the state authorities. So, but this opposite part number 5, those person who has intervened, he's another lecturer of my institution in a department, in other departments. He is getting his grantinate. He has no conflict. He has no lease against me. He filed an intervention petition. That also, my lord, by a misleading fact. What he says, he says
claimed any relief against
nothing, my lord. They no.
No. Whether if your relief is granted by the tribunal, this intervener shall be adversely affected.
Nothing, my lord. Nothing. If I will get or I will not get, he's getting his salary. He's continuing. I have no conflict interest with him. He's in lecture Odia. I am a lecturer in history. Now my grantinate is withhold or not withhold. That is the subject matter of challenge in the tribunal. What the lecturer Odia will say.
No, but how is that going to prejudice you?
My response submission is, my lord, if a person is not a necessary or proper party, why such a petition will be entertained by the tribunal? My objection, I have filed an objection, and the judgment of the Honorable Bench, my lord, have decided that says if a person is not there, if he's,
He filed an intervention application.
My lord.
That intervention application has been allowed.
Yes.
According to you, he does not have any right.
Yes.
You filed an appeal against that.
No, I filed an objection before the tribunal. Tribunal not considered that.
You file an appeal, then you file another appeal before the division bench. We want to know how is that going to prejudice you?
My response submission
so much
is
so that you have come to this up to this level.
My response submission is on the merit of the case. The government is saying whatever the allegation against me, I am fighting out my litigation. This person is unnecessarily putting nose to my litigation. He has nothing today. But if such type of litigation persons will be allowed to participate in the proceeding, well, it is unnecessary lingering my process or harassing me in the process of selection. Adjudication. And when the law is well settled, my lord, my response submission is that a person who is not even a proper party, he cannot. If I succeed, I got the judgment of the Supreme Court, even in a case, if I object also, the court cannot allow it. Court can dismiss my case if ultimately found that yes, he was a necessary party or a proper party. They can dismiss my case, but the intervention application cannot be allowed. So that is this is a point of law only.
Yes, who are you for?
I am for that private case the intervention I was allowed.
Yes.
Lord, my case is very limited. Lord, here the lease, Lord, with regard to withdrawal of grantinate. Lord, grantinate, Lord, statute speaks that the college must be represented by the secretary with the principal.
This appeal has been filed by a college or an employee?
An employee, Lord, I am saying, and he is the principal. Lord, college is non-represented. What I am saying, and the allegation is by practicing fraud, he obtained the grantinate. And the fact-finding inquiry, the committee constituted a government and a team consisting of 3 high officials. They said that yes, after giving notice, you have obtained grantinate by practicing fraud, so happening the record. And after recalling the grantinate, my lord, he became the employee of a non-aided institution. He lost the status of aided. And once become the principal, he must be an employee of an aided institution. So once he lost the status, Lord, I was allowed to act as the principal IC. At this stage, I filed an application for intervention. And the honorable tribunal said that even if I am not principal or not principal, I am a lecturer. And once the statute said that the college must be represented by the principal cum secretary, and he is the petitioner and he is the opposite party, that the issue, and nobody is representing the governing body.
File your affidavit, you will see.
And the so far as yes,
File your affidavit.
Yes. And only to prolong the dispute. This is happening as a file. If you also dispose the matter, only the stage of
you file your, let us understand now are you proper party,
Yes,
how are you going to be adversely affected? File your affidavit. As requested on third level counsel for the petitioner.
There's a call in next.
Petitioner and learned counsel representing opposite party number
5. Respond number 5. 5, my lord.
5. To place this matter on 25th of June. So as to enable and counsel for the party number 5 to file a counter affidavit. Notice on behalf of 1, 2, 3. 1, 2, 3. So accept notice on behalf of party number 5.
I will take notice on OP4. Respondent number 4, I will take notice.
You can, how can you take notice?
No, I am the applicant. Well, I have to take notice. I will file requisites for issuance of notice.
Right.
For
Who is for
OP4.
the OP?
Respondent number 4.
Who is OP number 4?
Respondent 4 is the governing body of that college. Represented by the president.
Not required. We will
Not
see later.
Obliged.
Item 7. My lord, petition challenges is the order of honorable single judge dated 27/2/2024 at page 59, my lord. On the ground, my petition has been rejected. That on same prayer, the second petition is not maintainable. Therefore, petition has been dismissed on that ground. Your losses can come to page 60, paragraph 5, I am placing before us. On the face of such order passed by this court, the present petition has been filed inter alia with a similar prayer for a direction on the opposite partner one to consider the claim to get the benefit of promotion to the rank of professor. Since on similar issue, an order was passed by this court on 2/2/2022, petitioner, instead of taking appropriate step in this dispose of this petition, has again filed the present petition with same prayer. Therefore, this court is not inclined to entertain such a prayer on the face of the order passed by this court on 2/12/2022 under Annexure 4. It is open for him to pursue the remedy in accordance with the law, my lord. My lord, my first petition was that. In the first petition, I have prayed, my lord, your losses kindly come to my prayer at page 24, my lord, of the brief. You will also get, my lord, page 24.
Yes.
It is therefore prayed that your lordships may be graciously pleased and kind enough or orders and admit the writ petition filed and be pleased to issue following direction for appropriate consideration of the grievance of the petitioner and to dispose of his representation of the petitioner pending before the opposite party and to avoid the discrimination caused to him without having any basis whatsoever or any breach without getting any stigma or strictures, even if truly and sincerely had discharged the post in duty during his career. To grant adequate remedy and benefit applicable to him and were done in case of other contemporary colleague and co-employees, even junior in the rank, but had not PhD qualification. To grant opportunity for making appearance and to proceed in the matter and to review the scope of law as available and to do
all
it.
right. We will accept your submission. If you say that this writ petition was not filed for grant of scale of a professor with effect from 1998. This
88.
1988.
88.
All right. If you make this submission right now, that the earlier writ application was not filed for that purpose.
No, my lord, that I have filed a
Mr. You should be clear.
Yes.
Otherwise, you are
Yes,
misusing, the
yes, yes.
petitioner is misusing the process.
Yes, pardon.
Only because of the change of the language in relief, the
intention of the petitioner cannot be
Yes.
different.
So just tell us.
Yes.
We will record that and then we will consider.
No, my lord. My prayer was, your lordship kindly.
You should be clear in your submission.
Yes, I am clear. I am making it clear, my to your lordship, my lord.
Forget clear.
Yes.
Tell us, first tell us whether this application was filed with, in connection with your claim.
That relief, my lord.
Then so frivolous appeal.
My lord, your lordship
We will
kindly.
impose it with cost.
My lord, your lordship kindly
We
see
will
my.
dispose it,
No,
dismiss with
your
cost.
lordship kindly
No.
hear me for a moment, then your lordship may.
Yes.
My lord, I filed a writ petition that after my retirement, they gave me promotion to the post of reader with effect from 72, my lord. I claimed for the.
Mister, you tell us, we are repeating that again, that question.
Yes.
Whether the claim which you have raised in the present writ application, you had raised.
Ultimate claim is same, my lord.
Ultimate claim is same, then you have missed.
The way is, my lord, way is different. On the other way, I have come before losses, my lord. I prayed for disposal of the representation, my lord. That I made the claim before the authority.
Then you could have waited for disposal of representation.
My lord, you lost the kind. Then I filed, as they did not take any action, I filed an interim application before this honor court during Corona period, my lord. This honor.
We are not happy. We are inclined to express our anguish.
On me, my
This
lord.
is not, no, the way in which the matters are being conducted has been pursued by the petitioner. This is not the way.
My lord,
appellant.
he could not file the contempt petition. Till today, representation was not disposed of. I came before lordship claiming for that post only that scale of pay in another writ petition. There is no other way out except filing a writ petition, my lord. No other way out for me, my lord. If I will make a fresh representation, my lord, then, my lord, I have to file the writ petition with self-same prayer again, my lord, to dispose of my representation, my lord. I cannot compel, my lord, the government to dispose of my representation. I have no authority to say so, my lord. Then what is the remedy? Remedy is before your lordship, my lord, only to filing a writ petition only, my lord. No other way out for me, my lord.
We know.
No other way out.
Where is the order? Last
order I am taking to your lordship, my lord.
Last in the previous case.
Your lordship may direct that, let them dispose of that representation.
No, we will not do that.
Your lordship can come to page 48, my lord. Annexure 4 to the writ petition. Para 5. As agreed by the learned counsel for parties, this court, without expressing any opinion on merits of the case,
8/12/2020.
2022. 2nd February 2022, my lord, at page 48. Paragraph 5, my lord.
48. Page 48.
48, my lord. Annexure 4 to the second writ petition. You will also get, my lord, that too.
Yes.
As regards to by learned counsel for the parties, this court, without expressing any opinion on the merits of the case, disposes of the writ petition directing opposite partner 1 to consider the representation filed by petitioner via Annexure 6 series and pass appropriate orders in accordance with law within a period of 3 months from the date of production of certified copy or authentic copy by this court, my lord. Then, this order was not complied with. I filed the IA, my lord. I am giving the IA number, my lord, to your lordship. For implementation of that order.
Was that permissible? Could you file an interlocutory application?
No. After the disposal, it should not be wrongly
Should not
filed.
have. So that was wrongly done.
Wrongly done.
Alright. So where is your representation?
The representation, my lord, here I have not annexed that representation. Yes, lordship, kindly come to. One representation I have annexed page 50, my lord, annexure 5. After the disposal of the writ petition, I have filed it. At page 50, my lord. Elaborate writ petition on 7/12/2023, stating everything about my claim, my lord. I am an old man of 84 years, my lord, residing at Visakhapatnam. I suffered from corona, therefore I could not thereafter file the writ petition, my lord. Yeah, contempt petition, my lord. Now the contempt petition, when I came to Cuttack, that the contempt petition became barred by limitation. So I made a representation again.
No, but you must have brought on record the representations which you had filed in the earlier petition, which were directed to be
That is
disposed
the
of.
writ petition, my lord, that in earlier writ petition it was there. In the writ appeal, I could not. He has a genuine claim, my lord. He has a genuine claim, my lord.
He may be having a genuine claim, but his case is not being conducted properly.
I came in second writ petition. my
Second
lord.
writ petition, then
I did not find any other way out to except file a writ petition. No other remedy was available. Even I cannot pray for again the disposal of representation dated 7/12/2023 annexed as annexure 5. my lord.
we are not sitting in advisory jurisdiction, Mr.
I
Counsel.
know.
Do you think
No.
it was proper for you to file a writ petition for the same relief?
Same relief when the second petition was not disposed of, my lord. Second petition, my lord. Then except coming.
But that was the direction to dispose of your representation.
Earlier
Then you file an IA.
That was
for
wrongly-
implementation.
Wrongly advised. He was wrongly advised. File an. I admit that one.
The present writ application has been filed. Putting to challenge an order passed by a single judge of this court dated 27/2/2024 in WPC number 4055 of 2024. That's all. By the said order, the petitioner's writ petition filed and the appellant's writ petition filed under Article 226 of the Constitution has been dismissed mainly on the ground that with the similar pair, the appellant had approached this court by filing earlier a writ petition bracketed C number 41866 of 2021. First off, the said writ petition was disposed of by an order dated 2/2/2022 with a direction to dispose of the petitioner's representation. Bracketed annexure 6 to the said writ petition. Next, assailing the order passed by the learned single judge, learned counsel appearing on behalf of the appellant has submitted that the relief which the petitioner had sought for in the earlier writ proceeding was different from that sought in the subsequent writ application. In the present writ application, that is the WPC number 4055 of 2024. So he submits that in the earlier writ petition, the petitioner had filed, had sought for a direction for disposal of his representations. Stop. Learned counsel for the petitioner, however, does not dispute the factual aspect that the petitioner's claim in his representation, in his earlier representations, were directed to be disposed of. The representation which is representation. The petitioner had claimed promotion to the post of professor in the discipline of zoology with effect from 30/8/1988, retrospectively, with all consequential and financial service benefits including retirement benefits and pension, etc. Full stop. Next, it is peculiar to note that after this court's order, after the aforesaid WPC number 41866 of 2021 was disposed of by an order dated 2/2/2022, the appellant chose to file an interlocutory application in a disposed of matter for implementation of the said order dated 2/2/2022. Full stop. Next, in the subsequent writ petition, that is WPC number 4055 of 2024, the petitioner sought for the following relief. Oh. With the subsequent writ petition, that is PW so and so, was filed with the following prayer. Stop. Next, we when counsel appearing on behalf of the petitioner appellant has submitted that since the opposite parties respondents did not dispose of the appellant's representations, despite this court's direction by order dated 2/2/2022, the appellant had no other option but to file the second writ application. Stop. The said submission, comma, in the court's opinion is completely misconceived. Stop. If the petitioner had any, appellant had any grievance relating to non-compliance of this court's order dated 2/2/2022, he could have filed an application alleging disobedience of this court's order. First off, learned single judge, comma, in our opinion, has rightly rejected the dismissed the petitioner's writ application. First off, we do not find any merit in the present intra-court appeal, which stands dismissed. So who is the university or the university?
My lord, the higher education department.
What's up? Next, it however goes without saying that the petitioner shall be at liberty to pursue his representation in this regard before the appropriate authority. In the light of this court's order dated 2/2/2022, passed in WPC number 41866 of 2020.
One observation, your lordship, kindly give my lordship, direct that the petition has not been disposed of, let them dispose of it. Unless other avenue is not there to my lord. Only one observation, it will, my lord, suffice the claim of the petition.
You could have filed a contempt petition, you did not do
Contempt it will be barred by limitation.
that. That way, that could have been seen.
Item 8.
May I please, Your Worship? Your Lord, the petitioner has challenged the order of the Honorable Single Judge, which is available at Annexure 5. It starts from page 37. Your Lord, the pertinent page is page 42, my lord, for a moment.
Page 42.
42, my lord. 42 of the Honorable Order of the Honorable Single Judge, my lord.
Page?
Page, my lord, 42, Annexure 12.
Yes.
My lord. Para 7, my lord. May I read it, my lord? At this juncture, this court is not inclined to grant any relief to the present petitioner since he himself has abandoned his job. When the petitioner was transferred, it was incumbent upon the petitioner to join in the post where he has been transferred. But by not joining the said post, the petitioner defined the authority of the employer. My lord, here, my lord, my humble submission.
Para 6 is
So far,
para 6 you have.
Para 6 is, my lord, a bare perusal of the record shows that the petitioner has voluntarily abandoned his job by not joining at the new place of posting, despite of the fact that the authority has insisted him to join in the new place of posting, but he is preferred to proceed with unnecessary litigations by this court, thereby wasted the 4 years time, valuable time of his life. Then, my lord, 7. My humble submission would be, so far the abandonment of service is concerned, all through I was working. Regine, my lord, kindly have a glance to Annexure 6 for a moment. It is at page 23. (23) is the order issued by my authority CDMO cum district mission director. The staff under order of repositioning by the order dated such and such are deemed to have been relieved from their duty with the effect from 28/8/2015 afternoon, and they are directed to report in their place of repositioning on or before 29/8/2015 positively. By this process,
Where is your engagement order?
my lord, my engagement order is at Annexure 1, my lord, page 16.
Yes.
My name is Arjun Kumar Naik, my lord. My place of posting was CSC, Chudapalli. And here, my lord, this is issued by the CDMO. As
When was this met?
My lord,
This is of which year?
this
2011?
is of the year 2011, my lord.
Yes, but this was only for,
26/3/2011. I was working since then.
so only for 11 months.
No, my lord, it is this is started since 2015, my lord.
2000
I was working since 2011.
2011.
11.
But your appointment was only for a period of 11 months.
11. Subsequently, it was continued, my lord, by OFO extension order.
Where is that?
My lord, Annexure 3, my lord, for a moment. 27/6/2015.
Yeah.
Page 18, my lord. While I was working as such, I have been given so cause notice for my performance.
Sir, the first question is, what right do you have to continue?
By way of subsequent order of extension, my lord.
Where is that?
No, in fact, so for this intra-court appeal is that I have not annexed. May I be permitted to file it by additional affidavit?
Not sorry.
My lord, Annexure 4, my lord, for a moment. That is very much clarifies my status.
Yes.
Annexure 4 at page 19.
Yes.
This is the order I am reading it out. As per the recommendation of the repositioning committee in its meeting held on 11/6/2015 at
Sir, we are in 2024.
Yes, ma'am.
What right do you have to hold that post? That is the only question.
My lord. My lord, since 11, my humble submission would be, since 11 to 2015, I was continuing. It is not disputed. While I was continuing as such, I have been repositioning to some other blocks, my lord, by the authority.
Mr. Counsel, if we allow your writ appeal today, what will happen? Under what authority you can be reinstated?
That is.
That is the.
But that has not been taken care of so far. The
We can take care of that.
continuity is concerned, my lord.
We can take care of it.
And by virtue of this court order also, there is a status quo order. It is in my favor and it is quoted in page 7, my lord.
The status quo order passed when?
It is passed on 16/11/2015, my lord.
Status quo means status quo.
No, status quo
You
by,
were there in your home. You were in home.
by that time I was continuing. While the matter stood thus, they have gone for a new advertisement of the contractual employees, though we are continuing on contractual basis in 2011.
Sorry, sir. An order dated 4/4/2024, passed by a single judge of this court in WPC number 30413 of 2020 is under challenge in the present intra-court appeal. So stop. The it appears from the materials available on record that the appellant was initially engaged as block data manager on contractual basis and was posted to contractual basis for a period of 11 months and was engaged as block data manager on contractual basis. Posted to Community Health Center, Turapalli, in the district of Bolangir.
Bolangir.
Stop. The initial engagement letter order of the appellant has been brought on record, which clearly mentions that his appointment shall be on contractual basis for 11 months and liable to be terminated at any time without assigning any reason. Stop. It appears from the impugned order of the learned single judge that the petitioner was repositioned to work at Community Health Center, Ghasia, after due approval of the repositioning committee. Stop. The appellant was relieved from the post of block data manager from Community Health Center, Churapadi. Stop. He, however, did not join the new place of posting and approached this court by filing WPC number 12086 of 2015, which came to be disposed of with a direction to the respondent number 1,
Hey,
to consider and dispose of the appellant's so-called reply. Stop. Stop. An order was passed on the petitioner's so-called reply. Stop. The appellant, however, did not join at the transfer post. Stop. He This is third writ petition.
Exactly.
The petitioner again approached this court by filing another writ application, giving rise to WPC number 20172 of 2015. Full stop. In the said writ petition, this court passed an interim order requiring the parties to maintain a status quo as regards the post which the petitioner held, comma, till 8/12/2015. The writ petition was finally dismissed. Writ petition, that is WPC number 20172 of 2015, was dismissed by an order dated 17/8/2018. Full stop. Next. Then single judge has noted that the petitioner appellant voluntarily abandoned the job by not joining at the new place of posting. Full stop. When counsel appearing on behalf of the appellant has argued that what is your submission?
My lord, my submission is, I was not nowhere abandonment of service. I was
That
all
the
through.
appellant had not abandoned his service, rather he was pursuing his case before this court by filing writ applications. So, next. In response to a query made by this court as to what right the appellant had to continue against the post, comma, his engagement being contractual in nature for limited period, comma, when counsel has not been able to give any satisfactory answer. Stop. Further, it was specifically mentioned in the engagement order that the services of the appellant could be terminated without assigning any reason. Stop. Next, considering the conduct of the petitioner and taking into account the facts and circumstances of the case, we do not find any legal infirmity in the impugned order requiring this court's interference in an intra-court appeal. Stop. This appeal is accordingly dismissed, being devoid of merit. Yes.
Item 9.
Well, here, the petitioner is a nursing college recognized by Odisha Midwives and Nursing Council.
What do you want?
My lord, the issue herein is the opposite party university has de-affiliated us in the middle of the session without assigning any reason. And moreover, they have issued a letter for conducting second semester examination, that is after with a delay of 2 years. And they have recalled that notice in respect of only our college. My lord, we have followed all the procedures.
Where is your order? Where is the order you have challenged?
My lord, I have challenged Annexure 5, my lord, page 32. My lord, this is where they have de-affiliated me without assigning any reason, my lord, in the middle of the session. And
It was not in the middle of the session.
yes, my lord, my lord. Uh, our first semester examination was to be conducted in the month of October 2021, and it was conducted on February 2024 with a delay of about 2 years and 6 months. And when the student agitated, they
You were granted affiliation when?
my lord, it is I have annexed that annexure 2 page starting from page 23, my lord. There are 3 affiliations.
The affiliation was granted when?
My lord, latest on 2/1/2024, my lord, page 25, my lord.
And the first?
2nd of January 2024.
First affiliation was granted when?
First was affiliated on 28/9/2022.
28/9/2022.
Page 26, my lord.
For which session?
My lord, it is for session 2021. On the first line, it is stated. Grant of NOC for BSc nursing course with 66 for the session 2021.
And for the next academic session?
My lord, on the page 2025, page 25, it is for the academic session 2021 to 22 and 22 to
And what is this? It says wide notification so and so 2/1/2024 is hereby drawn.
That is page 25, my lord.
Page 25.
Yes, my lord. This is withdrawn, my lord.
This is what we are saying, that this was the affiliation for these academic sessions were granted in 2024.
Yes, my lord. They're acting with a delay of about 1 to 2 years, my lord. And this
is not permissible.
My lord, for the year 2021, they have never conducted any exam. 2020.
If they have not conducted any examination, affiliation cannot be granted.
My lord, affiliation.
Just the affiliation could not have been granted in 2024 for academic session 2021-22. It is impermissible.
But my lord, on the basis of that affiliation, they were supposed to conduct semester examination by the university.
Mr. This affiliation, this order is per se on the face of it illegal.
My lord,
but patently illegal, this notification 2/1/2024. So therefore, we are asking again, let us see, when was the affiliation granted for the session 2021-22?
My lord, 2021 is at the page 26 and
page 26.
Page 26. This is for the year session 2021 issued on.
NOC has been granted.
For
not
affiliation. But they consider this as affiliation and.
No.
My lord.
It has been rightly done.
My affiliation was granted.
Where is that?
That is page 23.
My lord.
Just a minute.
In inviting a reference to the subject section and directed to inform you that verification is to be
decided to grant
for grant of affiliation. It is decided to grant provisional affiliation to the BSc nursing course
Could not have it.
That is serial number 2.
It could not have it.
But for the 21, 22, 22, 23, provisional application is granted.
Cannot be done.
But on this basis, they must have taken.
See, if they had taken admission for 21, 22 without affiliation.
On page,
Mr. Counsel, they have withdrawn something which was illegal.
based on, this is the practice they follow for all colleges, but
We don't follow the practice, we follow law.
well, based on that, we have taken admission, and based on this
You
document, they
could
have
not have
conducted.
taken admission. How could have taken admission for the academic session 21, 22?
My lord, they have also conducted first semester based on this in the year 24 with a delay of 2 years, my lord. By acting,
So do you want us to declare all the results illegal?
oh my lord, but
We can do that. Because we will follow what is there. We will follow the letters of law. If this is happening in the state of Odisha, then that will be the result.
then my lord, they may be noticed why they have issued this.
Where is
Because
it? What notice? You tell us. You have filed this petition. You tell us. How could you admit students for the academic session 2021, 2022?
my lord, based
How
on,
could you admit students? Why did you admit students when your institution was not affiliated?
my lord, there must be some notice prior to this. There must
No,
be some
you have
notice prior
enclosed-
to this, so
You have enclosed annexer 2.
annexed to my lord.
That is dated 24th November 2023.
My lord,
So in 2023 only you got provisional affiliation.
yes, my lord.
Then prior to that,
There
there
is-
was no affiliation.
There is no bar under the Act. Is there any bar under the Act? Yeah,
My lord, I have to.
must be. University Act. Someone is appearing for the university.
No, this is nursing council.
Nursing. Nursing council
Mr.
state, it has to be
Mr.
affiliated
Mahanti,
with one university.
RC Mahanti, yes.
No, but the university is the,
Indian Nursing Council is concerned, we are appearing, let him.
no,
But
how-
you are not there. This is Fakir Mohan University.
Why is this happening?
TK Satpathy must be there. Fakir Mohan University, who is it?
Sambalpur University, that item is.
No, Fakir Mohan. A nursing college. This is a nursing college.
Yes.
You are not dealing with it. You are not dealing with nursing colleges.
We are nothing, we are dealing with nursing colleges, but we are not made party. We have not solved it.
You are appearing for a DMT normally.
DMT.
Usually you appear for DMT.
no, but the question in this thing, here, NOC was granted.
My lord,
Now, after NOC, you were required to get affiliation.
yes, my lord.
Unless you got affiliation from the university, you could not admit students. Because you can admit students against a course with the university, that university. So that is not there.
Mr. Mishra, what is that provision where affiliation is granted to the affiliation in the university? What is that provision?
The Education Act is an ability, but here, something.
No, For nursing college, affiliation is granted by Fakir Mohun University.
Every institution is required to be affiliated to a university.
There must be university statute.
Council will give the NOC and university will grant affiliation. Because it's a degree postgraduate, university has to give affiliation.
So unless the university grants affiliation, how an institution can admit students?
Cannot. Like in Millards, undergraduate colleges.
So is there any decision on this point? Maybe.
Normally, when the students on the basis of NOC, students are admitted and the application comes as a data sheet.
That is very difficult.
Yes, but as Manuel is posing the question, whether it's legal or illegal.
That is very difficult, and if required, we will hold that. Then all the qualifications shall be in, maybe
So why have
under
they,
scrutiny.
why have they picked up this institute?
All are being granted by the university.
Now, why have they picked up this college?
Very difficult, Mr. Counsel. If you want,
My lord, it may be agenda. I will check out if any other earlier document issued to the petitioner college.
no, it is clear from Annexure 2.
No, my lord, if prior to this.
No question of earlier.
University statute. That university statute refers to provided our affiliations.
Statute, sir?
We should not be able to do it.
University law, so.
None of the publications publish this university statute.
No. It's only
Gazette notification or university council can only produce. For all universities, one or different universities, they have their own.
Because all the universities have been subsequently established.
We had earlier only Utkal University and OUT.
No, Mohammed, Utkal and Sambalpur.
All right.
There are so many compulsory universities.
It's a very serious matter. See the definition of college under the Universities Act.
Structure. Structure.
difficult. Come to section 18. Very difficult. Who will assist us? Huh?
I'll survey a copy today.
Let's this matter on Monday. It will lead to serious consequences.
Yes, my lord.
And there is a division bench decision of Patna High Court on this.
My lord, now they have also served a letter for conducting.
The decision specifically says that an institution not affiliated cannot admit any student. So there is no question of till affiliation is granted, you cannot admit.
Annexure 1, that is mining plan for blasting permission. The Lordship may see page 28.
Page 28.
8 of the mining plan. Before release of agreement, prior to that, because planning.
No, see,
my lord.
You must understand my handicap also. I'm not very well versed with the law. So you tell us what is the your law, I mean.
Lordship may see
Yes.
that I am just placing how the mining plan is approved by the government. Your Lordship may see page 28.
Yes. Page
28, running page 28.
28.
8. Clause B. 10 clause B, mining. If semi-mechanized or mechanized number, type and capacity of machines to be used, my lord.
28.
Yes, my lord. Page, running page 28.
No, that is the first tell us,
my lord,
what is your right to get the license?
License has been
See
given.
the impugned order, that
Yes.
is most important.
All right.
Impugned order is annexure 8.
Let us see. Yes.
That is most.
Yes.
Request to grant permission for blasting for conducting the quarry operation, my lord.
Yes.
That was the impugned order on 5/2/2024. Permission was not granted, it was rejected, my lord. Hence, on the basis of the aforesaid reports, basing on the report of the Tahsildar, Lordship have a glance to the Tahsildar report.
Just a minute. So this power of the additional district magistrate
On behalf of
Must-
collector,
must have been exercised under some
yes, ma'am. That is there.
provision of law.
Yes, ma'am.
Where is that? Where is that provision?
My lord, Rule 16, procedure for auction of mining lease. It starts from Rule 16, my lord. This is minor mineral, it's not major mineral, your lordship. They treat it as major mineral, that's why they have rejected. Within the radiation of 200, it is permissible. That is the Tahsildar report.
Can you read it? We
My
cannot.
lord, page 86, annexure 5 series, the report of the Tahsildar, basing upon which the,
Come to annexure 8.
my lord, annexure 8, your lordship.
Yes, it's not
That
clear.
is improved order.
It's
Your
not
lordship,
clear. It's not legible.
annexure 8, the
Annexure 8
rejection
is
order
not
says,
legible.
rejection order on the ground of your lordship, that is 500 radius meters from the mining as danger zone.
Scanning not properly done. कहाँ हुआ?
It was rejected on the ground, your lordship may see the distance village point from the mining area is 415.03 meters approximately. As per DGCA circular, in the interest of the safety, my lord,
How much? 4?
415.03 meters. This is my area. We are not exceeding 500 meters. DGCA guideline says within 500 meters. Next, your lordship, place of firing as the danger zone. If it is 500 meters, it is danger zone, my lord. So far as basing on this, your lordship, the rejection order, the Tahsildar report, lordship, have a glance to page 86. My distance is 110 meters from lease out plot number 366P, my lord. 2 plots has been allotted in my favor, that is 6 acres, my lord. (366P), my lord, 1.5 acre. Then 374, that is 4.5, my lord. Total 6 acres has been leased out against this petition, my lord.
Yes, so what is wrong in the order?
Yes, my lord. That is 500 meters, but my place, your lordship may see that Tahsildar's report have a glance to page 86, my lord.
So this
a small made it. They has clarified that what is the distance, my lord, and there is no hospital, NS, railway, water bodies within 500 meters from the stone quarry, the present stone quarry. There is no bird sanctuary. That is 4 guidelines are there from where they cannot give permission within the radiation 200 meters from the stone quarry. So 200 meters, my lord, they may reject because 4.13, 500 meters is the, my lord, cut off. It is permissible, even if not accepted, but next to 4.5 acres, that is 200 meters, my lord. That is permissible. 5 years I have taken the lease. Lease already start 2022, 23, 1 year has lost.
The lease is there with you.
My lord.
There is no.
Basing on, my lord, mining plan and the environmental clearance.
Blasting, they have not permitted you that you can do mining, but not blasting.
That was rejected by the my lord collector. Your lordship may see that mining plan. That is also permissible. Your lordship may see. Within 200 meters. Within purview of 200 meters, I am permissible. Beyond 500, not permissible. Within 500, also not permissible. My place is 4.13, which I have shown to your lordship. That is 1.5 acres. And 4.5 acres is within 200 meters.
What is this DGMS circular?
Circular, your lordship may see. That is annexure.
You were seeking permission for blasting.
my lord.
All right.
Unless until blasting is made, how can I run the stone quarry, my lord? Minor mineral.
There are other methods also. Blasting.
Manual lordship can I?
Yes. Blasting
As
so far.
on
blasting is-
date, manual,
See, the reason has been mentioned.
my lord.
As per DGMS circular, in the interest of safety to all places within radius of 500 meters of place of firing as danger zone. So within the radius of, you are saying within 200 meters,
Yes, my lord. So that
within-
is permissible.
within 200 permissible and 500 not permissible.
Not permissible.
Wonderful.
That is the, my lord.
What a submission.
200 meters is permissible.
This is submission. We are not able to understand this.
At
So you
phase-
are saying that 200 is permissible.
Within
500 is
200,
permissible, 200 is not
radiation within 200 meters, it is permissible. But beyond 500, that is the guideline. Well, you may see that.
How can you make this submission? According to you, within 200 meters, it is not permissible.
Permissible, my lord.
200 meters permissible.
Permissible. 500 not permissible. Beyond 500, not permissible.
Is just reverse is saying.
So, lordship, my lord, rejection was because within the 500 meters that was rejected. But my land, that is within 200 and other one is, my lord, 4.15.
So you are admitting that cannot be permitted in view of DGCA circular.
500 meters se hele haboni. Beyond that, my lord, 500 and beyond haboni. But below, my lord, less than 5.
What a submission, Mr.
Radius
What a submission. See, something
My lord.
which is within the radius of 500 meters
Yes.
shall also be within the radius of 200 meters. Shall also be within the radius of 400 meters.
My lord.
So whatever within 500 radius of within 500 meters is prohibited. So you are saying
500, yes, my lord, that is prohibited. But up to 200
not permitted.
not prohibited.
Fine.
That is. Lordship,
Please.
My lord, what is the case of the petitioner is that he has complied all formalities which are required for the purpose of operation of the mines. This is a minor minerals. But in addition to it, for blasting, he has to seek permission from the
Yes,
collector.
yes.
Collector has passed the impugned order with reasonings and obtained the report from the field authorities. That it is endangered to the life and property of the local villagers.
Yes.
So his mining operation is not restricted. What your lordship has rightly pointed out, his mining operation is not restricted. He is not allowed to blast because it will endanger the life and property. This is a question of life and
And
property.
can you imagine the court interfering with such orders?
Finding of the factual finding of the collector.
with regard to lordship, Tahsildar report, basing on the Tahsildar report and the police report, this order has been, impugned order has been passed, my lord.
right.
Lordship, may I have a glance to the Tahsildar report?
What? 400 meters.
Yes.
Only recommended.
Recommended that there is no,
Is it sacrosanct?
yes, my lord, 5,
No, there is no.
your lordship, may I read?
Please read.
A small school building, an Anganwadi and a surrounding by a small boundary is situated at a distance of 110 meters
110.
from the leased out area of plot number 366. Then there is a small human habitation at a distance of 155 meters from the plot number 3 in south direction and 250 from plot number 374. There is no hospital. NH railway,
What
bodies,
placing there?
my lord.
That doesn't support your case. You are submitting that it is 500 meters, not 200 meters.
Permissible within 200 meters. That is the guideline. my lord.
Not permissible within 500 meters. And 200 meters is not within 500 meters. This is what you submit.
Lordship, may I submit the mining plan, Lordship?
Mining plan, there is-
Mining plan, your Lordship,
No.
blasted
Do you have-
using light,
do you have
you can use the
just-
light, my lord.
Just a minute. Do you have the DGMS circular anywhere?
That is, your Lordship may see. Page 100.
Page
100. All owners and agents, managers of mines, dangerous due to blasting project lines.
Last part.
the petitioner holds leave executed in his favor on 12/9/2022 for mining minor mineral comma by whom minor mineral. Stop. He had made an application seeking permission for blasting for conducting quarry operation, which has been rejected by an order passed by the additional district magistrate Sundargarh dated 5/2/2024, which is under challenge in the present writ application. First off, the said order has been, which is that order? Sorry. Which is that order?
Annexure 8. Annexure 8.
Right. No, but there is difference between what is there. See. State order is being assailed in the present writ application filed under Article 226 of the Constitution of India. First off, on perusal of the impugned petitioner had made an application. Which has been rejected as communicated to him through later dated 5/2/2024, issued under the signature of additional district magistrate Sundargarh. Stop. On perusal of the impugned order itself, it appears that the permission sought for has been declined, taking into account DGMS circular dated 31/1/2023. Dated 31/1/2023, which in the interest of safety, treating all the places within the radius of 500 meters of place of firing as danger zone. Stop. Next, learned counsel appearing on behalf of the said rejection is based on a report submitted by the Tahsildar and Tahsildar Bisra and mining officer Raurkela. He's also there. And a mining officer / competent authority Sundargarh. Stop. Sundargarh, based on a joint verification.
Joint inquiry.
Joint verification conducted by the conducted by him with the revenue officials. So stop. Which is this? The relevant portion of the report of the Tahsildar and that of the mining officer Raurkela read as under. One, district officer Tahsildar Birsa, page 98, page 98, page 99. Next. Learned counsel appearing on behalf of
Your
the.
lordship may note also the SP report is there.
Where is that?
At page 107. He
The
has categorically said that may not be granted.
Superintendent of Police
Raurkela
submitted
inquiry report.
has also submitted
report.
had also submitted a report which has is it part of which annexure is this?
This is at page 107.
No, annexure.
3/8/2023.
This is annexure. Written in
7 series.
7 series. 107 page.
Annexure 7 series, which
Report dated 3/8/23 wherein it has been mentioned that there are so many houses located within 500 distance from the proposed blasting spot, and there was apprehension of danger to life and property of the above villages, if the blasting work was to be done. So stop. It is also pertinent to mention that the inquiries were conducted by the Tahsildar. Inquiry was conducted by Tahsildar in the light of a communication made by the additional district magistrate Sundargarh for the purpose of considering petitioner's application seeking permission for blasting for conducting the query operation. So, Learned Counsel appearing on behalf of the petitioner has submitted that in terms of the said DGMS, after having considered the report of the Tahsildar and the mining officer, the additional district judge has rejected, additional district magistrate Sundargarh has denied permission for the with the following observations. Page 108. If there is 1 or 3, 4, why it is 3 and 4? Why is this 3 and 4? Where is second and third? 3 and 4. Learned Counsel appearing on behalf of the petitioner has submitted that as per the aforesaid DGMS circular, prohibition is with respect to the area within the radius of 500 meters and not within 200 meters. This is your submission. Stop the said submission is you should not say that. Only illogical. So stop this. We do not find any reason to interfere with the impugned order, which is based on the DGMS circular. This writ petition has no merit and is accordingly dismissed.
But they have not considered the own plan, mining plan. That is there on clause
you can
10B.
Item 11.
Actually, my lord, this is the matter of only agreement matter. The agreement made on 23/4/2019 matter for 5 years. Accordingly, I have deposited the royalty.
Representation.
My lord,
Representation were filed.
yes, my lord. I worked only 4 years, up to 2021 to 2023. But 26, 24, I have not done any, but I have deposited royal amount.
Are you entitled to such refund?
My lord,
You are entitled to refund.
Actually, he is seeking extension, but there is no provision under the
He
ordinance.
is saying that if you don't extend, you refund the amount of royalty.
That is a factual dispute, whether he has worked for 4 years or not.
I have worked 4 years.
Might not have worked. So this 24/4/2024 is over.
Yes, ma'am.
When did you file the writ petition?
The 26/4/24.
26/4/24.
Yes, ma'am.
After completion of the period.
Yes, ma'am. Before that, I have filed the representative that is another 13 months.
How are you seeking this direction? Considering representation to allow him to run query till 24/4/2024. And you are filing the writ petition on 26/4/2024.
To refund the royal. Annexure 12. First, I have been represented to before the sub-collector additional district master manager.
What?
The representation.
Representation we will not do. We will decide. You're right.
Only to refund the royal.
Under which provision? Why?
I have deposited already 2023 to 24, my lord. But it is not allowed, my lord.
How?
That is annexure 8, my lord.
Age.
Age 46.
So by annexure 8, you were stopped.
Yes, my lord. Then I complied with
Your agreement period ends on 24
24/4/2024.
2024.
Yes, my lord.
So April 2024 was the 5th year. That is the end of the year.
Yes, my lord.
So you applied for extension in January 2024. After 9 months.
My lord.
Of the
18/10/2023, my lord. That is the annexure 11. Not 12.
No.
I have deposited the amount that is annexure 7, my lord. Page 45.
I am on agreement.
My lord.
I am on agreement. Your agreement term.
Yes, ma'am.
Ends in April 2024. You have filed representation.
Yes, ma'am.
In January 2024.
First, my lord, 4 November 2023, my lord. Page 54, my lord.
It's up to page 46. Yes. Sure. This is August
Annexure
2024. Now, after completion of the fourth year, he is filing the writ petition. So you could have, your mining was stopped in August 2023 itself. You could have come then.
Annexure 8 is important, your lordship may see at page 40.
That we have seen.
Yes. This is not challenged, and the reason for directing them to stop the construction is attributable to them. They have not complied certain formalities as per the rules. and we asked them to comply the formalities and start the operation. They did neither they challenged it nor complied. So how can the state be responsible for stopping the operation of the query?
Hit the page. I have to work, my lord, for 3 months after along the page 49, my lord.
This writ application has been filed. Questioning the inaction of opposite party number 2 in not considering the petitioner's representation dated 5/1/2024, bracketed annexure 13, to allow him to run the query till 24/4/2024 as per the 5-year lease agreement. Stop. An alternative prayer has been made to refund the royalty amount paid by him for the year 2023-2024, along with security deposit in connection with auction notice number 2187 dated 28/6/2018. Stop. It is not in dispute that the lease to query, comma, as per the lease agreement, comma, the petitioner's right to query was coming to an end on 24/4/2024. So stop. On 10/8/2083 itself, a communication was made by the mining officer cum competent authority, Panpost subdivision Sundargarh, requiring the petitioner, informing the petitioner about non-compliance in relation to petitioner that he had not submitted statutory documents, certain statutory documents to the Tahsildar Raurkela. Stop. By the said communication itself, he was also informed that he had not submitted annual and quarterly returns as per Rule 33 bracketed 15 of the Odisha Minor Mineral Concession Rules 2016 from the month April 2023 onwards. Stop. While asking the petitioner to comply with the deficiencies as pointed out, comma, he was asked to stop all mining activities on the said sand bed forthwith until further orders. Stop. Next, the petitioner did not challenge the impugned communication dated 10/8/2023. So stop. It is not his case that the petitioner complied with the requirements of the letter dated 10/8/2023. So stop. On 26/4/2024, the petitioner filed the present writ application seeking direction as noted above. So stop. Next, this in the petitioner having not challenged the said communication dated 10/8/2023 and thus having accepted that, comma, in the court's opinion, cannot claim refund of the amount of royalty. So stop. The prayer that the petitioner should be allowed to continue mining operation till 24/4/2024 is preposterous in a writ application filed 2 days thereafter on 26/4/2024. Stop. This application is devoid of merit and is accordingly dismissed. Item 12.
Remember this material yesterday, MBBS student exam materials.
What happened?
So far as the letter issued by the principal, we have already informed the blood council and seek for the confusion on these issues. And we have outing the response from the MNC. We have issued a letter 4/5/2005 and also issued letter.
No, but what about the examination, whether he can appear or not?
No, we have to take without any decision of the MNC, we cannot. Because this ambiguity, what has been referred in their principal has referred to the university, that we are communicated to the council. Council has not take response on these issues. So now thereafter, we have also formed a committee, and the principal also a member of that committee. And we have a resolution has been passed. May I please resolution? The representation of the concerned student was examined by the committee along with the present guidelines of the NMC. The control examination informed that MNC has been approached for clarification in this matter, which has not been responded.
MNC is what?
National Medical Commission.
NMC.
NMC, sorry, not NMC. The committee referred that any further decision in this matter shall be taken only after receiving the clarification of NMC. The committee recommends as special agent the case NMC clarification come in favor of their eligibility to appear. The meeting ended with the formal vote of thanks. Without any decision, we are not in a position to conduct the examinations. Therefore, the National Medical Commission has to take a call on that.
Whether NMC is a party?
Yes, is a party.
But tomorrow is the examination.
10th, your lordship.
We are promptly take action on this.
We have supplied, your lordship. Copy have been supplied to the MNC.
2, 3, if possible. You will take up. At 4 even, at 4. In the meanwhile, you will have to file an affidavit that if you finally don't succeed, then you will not claim any equity. All right, so you do that, you file affidavit. We'll consider, we may allow. Serve the copy.
Copy have already been solved.
Serve copy. And MNC.
Soft copy has been supplied. Now I'm supplying another copy.
And please give him the decision which you have taken, the resolution.
Yes, Your Honor, I'll file a memo, Your Honor, I'll submit with a memo.
To him.
Yes, yes.
Because he has to seek instructions. Please seek instructions. They will take up the matter at 4.
Yes.
And what will happen if we grant the interim order? This will be given admit start.
Tomorrow, Milord, I have to also discuss, Milord. In the meantime, I'll discuss the controller examination, what will be due.
So you can come at 2 also. We can take up the matter at 2.
Yes.
Nowadays, question paper are coming via mail.
Yes.
Or some secure.
That has to be
Electronic
because
device.
counting
That
the
admission
already
card
been.
It is online examination.
Online.
I'll take.
Then they can arrange it. Take instruction.
Obligations. 4 PM also. Taken up 4 PM or 2 PM?
Even before that, if something happens, because this is an examination matter, anytime you can come and tell the court if some development takes place in the meanwhile. Right, otherwise at 4 we will pass them on.
But the earliest you get the instruction.
Item number 13.
Item number 13, Milords. This case is regarding the validity of section 168A, where the period of limitation for adjudication under 73. Yes, Milords. Similar order your lordship has dealt, and these are the similar cases, Milords.
Yes. All right.
Yes, ma'am. Okay.
Item 14.
Plus 14, all the 4 matters I've given copy to my complied with given
Yes.
copies.
Complied with.
Item 15.
So I filed a compliance affidavit yesterday, of course. Whether my friend has got a copy or not, don't know.
I have not received a copy.
I'm giving you
In
lordship that I'm giving a copy of the compliance affidavit to my friend.
I don't.
If it has been complied with, then we can drop.
No, my lord. So what has happened, my lord, in this case, your lordship's direction was that it has a calculation has to be made. That calculation has to be given to us, and thereafter it will be the amount so due will be paid notice. Keeping the age of the petitioner who is already 70 plus. My learned friend
70 plus is nothing.
No, sir, he has retired, my lord, and he'll be getting hardly.
Say that
But he'll be getting. So, unfortunately, my lord, if they do not give us the calculation, and if they say that they have complied with your lordship's order in their own way, my lords, we will not be able to know, my lord, whether the letter and spirit of this order has been complied or not.
So whether the calculation has been given to you or
no, my lords, it has not been. I only pray.
There only not I've given the calculation. My senior may go through the details.
The calculation is there.
Annexure B/3 page 8. Complaint B/3.
Let me, your lordship may permit me, my lord, to
tomorrow.
And also tomorrow will not be possible, or subject to.
So
Can I pray for next week, my lord, so that I can go through the calculation?
All right. Calculation we will give you liberty to question.
Lord, again, my lord, I have to, my lords, come in a writ
contempt
petition.
proceeding, we cannot say that the calculation is incorrect.
No, what if, my lord, on the basis of records, my lord, if I demonstrate.
No, we cannot.
No, because your lordships have fixed one date. That is the date of acquisition of trained graduate qualification. So if, and thereafter, my lord, they give me a ACP, the increments. After 15,
We cannot enter into those disputes in a contempt.
your lordship may call it next week, my lord, let me just go.
All
through.
right. Right. As requested on behalf of the London AGA has stated that this court's order has been fully complied with. The top copy of compliance affidavit.
Yes, ma'am.
Has been served upon learned counsel for the petitioner. Stop. Learned senior counsel appearing on behalf of the petitioner seeks adjournment to consider the said compliance affidavit. As requested, list this matter on 1 week. Yes.
Item 16. Obliged.
May I please, my lord? My lord, the order Annexure 2, my lord, page 18. Running page 22, my lord. I am the respondent in writ appeal.
You are?
I am the respondent in the writ appeal, my lord. I am the
Sit for a while.
page 22.
Yes.
Against the interim order, my lord, the writ appeal has been filed. While admitting the writ appeal, my lord, your lordship passed the order at 22, my lord. But the respondent number 1 shall continue to get his.
Your loss of breath, Mr. Counsel, are you well?
Just.
Therefore, we just you can sit for a while.
5 minutes ବସିଯା। ଆରେ 5 minutes ରହିଯା କହୁଛି।
Yes.
But they have not paid the salary, my lord. Even if your lordship's direction in retail.
Where is the order?
Page 22. Lord, single judge directed to pay the salary, my lord. Then directed at para 11, if not paid, they shall appear before the court, my lord.
Why are you taking us to this order? This order is of division bench.
Yes, my lord. This order passed in writ appeal. In writ appeal, which is pending now, my lord. And I am the respondent. And here, while passing the order in writ appeal, my lord, your lordship directed page 22. In the meanwhile, it is directed that the impugned order so and so arising out of so and so shall remain suspended. But the respondent number 1 shall continue to get his monthly wages subject to outcome of this writ appeal. Despite your lordship's order, they have not paid my salary. Wages, my lord. Page 22. Last.
So you are not getting your monthly wages?
Yes, since August 2020.
Since August?
2020, my lord.
But I am appearing for the contempt. But the writ appeal is pending. But I have filed an IA for modification of that order. Since August 2020, the petitioner is not working. And this honorable court has directed to pay. And that amount is subject to result of the appeal. So in case the petitioner not succeed, we may not collect that money.
Therefore, you are not required to implement.
No, that is why I have filed an IA for modification.
When?
We'll comply, Lord. So
when did you file your IA?
The IA filed on 23 November 2023.
23. So you modified the order of this court. Because you knew that you may succeed in the writ appeal, therefore, there was no requirement of compliance.
No, we will comply. Then our
No, we
lordship
will not hear you till you comply with the order. All right.
Here I will appear for the state, Lords, the finance department, because my friend is for the transport department. Only question is here, Lords. Once they will comply, Lords, whether the compliance will from the date of order passed to the writ appeal or from the date that was passed by the honorable single judge.
No, it is very clear.
Yes.
It is very clear in the order. In the meanwhile.
Yes, Lord.
But the respondent number 1 shall continue to get his monthly wages.
So whether it will be current or arrear.
Do something.
Yes.
Current or arrear. At least since the date when the order was passed.
Yes.
Yes.
Otherwise.
That
Please do something and take a defense.
yes, that yes, that too will pay.
1 week. As requested
Both,
on
my
behalf
lord,
of the.
both cases. Tagged, my lord, both cases. In both the cases, same order.
As requested on behalf of the contemnors, list this matter on 1 week.
Item 17. 17, the lordship's order has been complied with. I have given a copy to my friend. Representation has been disposed of.
Yes, complied with it.
Item 18.
May I please, your lordship? Order dated 16/1/2024, my lord. Order was not complied with till today.
Where is that? Where is that order?
Page 4, para 5, my lord. 3 months was time was given.
Para 5.
Para 5, my lord. Page 4.
Yes. Who had to dispose of the representation?
Principal. Dr. Ambedkar Memorial Institute of Informational Technology, my lord. OP number 3.
OP number 3, someone is appearing.
Not appearing.
Is someone appearing?
Not appearing. Last time.
Issue notice.
Orders item 19.
Yes. No one appears on behalf of the. Yes, who is for the respondent?
My lord, I am for the CDA, my lord. On behalf of Mr. Mahapatra, my lord. They are not served a copy of the miscase, my lord.
What is this matter about? This is of 2014.
My lord, it's a disposal of case, my lord.
Disposal of case.
Disposal of case, and they have filed a miscase, my lord, in this case, according to the note of the position, my lord.
What is that? This case? 2016. Where is the miscase?
Miscase 15662 and flat 10.
Like 10.
They claim to be operating on the side of main road leading to the civil medical college and hospital, praying for direction to the Kotak Municipal Corporation to construct temporary shop rooms in the specific vending zone and allot the same to them, for which payments have been made by the petitioners.
No. What is the miscellaneous case? Which miscellaneous case? 15662.
No.
There is no one to press. Miscase 15662 of 2016. Bracketed flag 10.
And another flag 11.
And
that flag 11.
11. And so and so. So both the applications are dismissed.
Item 20.
Lord, during pendency of a disciplinary proceeding and a vigilance case, my lords, the learned single judge has directed that grant promotion. This is contrary to two judgments of your lordship's court. One is Joseph Barik, which is 2023 volume 2 OLR Cuttack 361. I'm sorry. Joseph Barik is 2023 2 OLR Cuttack 361. And one of my Lord the Chief Justice, sitting with my Lord Justice Raman. This is WA 321 of 2022. So on merits, my Lord, I have a complete case. Now, my Lord, we have filed an application for limitation. There's a delay of 279 days. And my learned friends are relying on that Susuma Manjari case. Would your lordships kindly have a look at that Susuma Manjari case? That is filed along with my learned friend's objection. Okay.
Objection.
My lord, can I hand over copies to your lordships?
Objection is at flag D, my lord.
Yes.
And
Kindly see, my lords, the very first paragraph, paragraph 3, man. My lords have paragraph 3.
Yes.
The petitioner has challenged the order dated 26th of February 2019, passed by the OAT Bhubaneswar in OA number so and so. The present writ application was filed. My lord, the writ petition was filed on 27/4/2021, more than 2 years after the impugned order was passed. Yet, there is neither an application for condonation of delay nor any explanation of such delay in filing of the writ application. So, my lord, Surama Manjari was not considering a case as to what would be the position of law if a limitation application is filed. In my humble submission, my lords, this is not a precedent to say that this honorable court has decided as to how a limitation application is to be considered. This is my first submission. Therefore, my lord, Surama Manjari has no application while considering a section 5 application. And all these observations that have been made have to be read in the context that there was no application. And if your lordships kindly see, my lords, how Surama Manjari ends. Kindly see, my lords, paragraph 6 at the last page of the judgment. My lords have paragraph 6, my lord. My lords have paragraph 6.
Yes.
The writ application is accordingly dismissed on the ground of laches, not on the ground of delay.
Yes.
Now, your lordship, see, my lord, how the Supreme Court has looked at these kind of judgments.
No, there are two aspects.
Yes, I'm grateful.
One is
yes,
that was a writ petition.
Yes.
Where there was no requirement of
I'm grateful.
filing an application for
I'm grateful.
condonation of.
I'm grateful.
That is one.
Correct.
But the delay aspect was there, delay and latches. Whatever has been held in
Correct.
paragraph 6.
Correct.
That is another aspect.
Yes.
The crucial aspect is
my lord,
that in paragraph 5 of that decision.
Yes, my lord.
Certain Supreme Court's
Judgments have been referred. My lord, may I put it very simply? My lord, once your lordships come to a conclusion that there is a case on merits and there is a strong case on merits, like the present one, my lord. Strong case on merits and we're getting close to lunch. Just have a two-page judgment. This is a case where there was a delay of 800 days. And your lordships yesterday were shown one judgment of the Honorable Supreme Court. Anup Senapati. This was regarding grant in aid. And if your lordship sees minutes, may read this. Delay condoned, subject to so and so. If the amount is deposited within stipulated time, the special leave petition shall stand dismissed so and so upon deposit. Then kindly see, Mr. So and so senior counsel invited attention to the judgment in order of 16/9/2019, passed in civil appeal number so and so and all other connected matters. The issue involved in the matter was set out in para 1 of the said judgment. Then they quote it. The conclusion is the conclusion drawn by the court as set out para 31 is as under. It is apparent that in consideration of para 4 of the order dated so and so, the only saving right is to receive the block grant, and only in case of grant in aid has been received on or before the repeal of 2004, it shall not be affected, and that the order of 1994 shall continue only for the purpose that no other rights are saved. Thus, we approve the decision of the High Court in so and so. Relying on this said observation, it was submitted that only a right was saved was to receive block grant, and only in these cases grant in order was received on or before the repeal of the order of 2004. It is further submitted that the decision of this High Court in Loknath Behra was approved by this court. Exactly contrary situation has now been accepted by the High Court in the present order. Exactly like our case, contrary to your lordship's judgment and the other judgment. Now see, kindly see what do they next. We must, however, state that the matters are disposed of with the High Court, as the petitioner in every case was delayed by at least 800 days. In these circumstances, we pass the following order. Delay condoned, subject to so and so. The submission to your lordship is this. Once your lordships find that an order is clearly in contradiction to the settled principle of law, then those cases, for ends of justice, your lordships have always said that we will condone the delay.
And what is there in those decisions which have been taken note of?
My lord, can I trouble you after lunch, my lord? I'm eating into your lordship's lunchtime.
Oh, yes. Sorry. I thought 1:30, but now.
Not only making him happy, making me more happy. I go back relieved every day. My lord, your lordship asked me a question on that Surama Manjari judgment. That there are some judgments referred to in that. So if your lordship sees, two judgments have been referred to. One is at page 2. My lord Sahib, Surama Manjari, my lord.
Yes.
The first judgment that has been referred to is State of Madhya Pradesh versus Verulal. My lordship shall have it at paragraph 4. State of Madhya Pradesh versus Verulal.
Paragraph.
First page, paragraph 4.
In this.
Yes.
Yes.
My lord Sahib.
Yes, Lord.
And the other judgment, my lord. The other judgment referred to, my lord, is at is Chief Post Master General over the page.
Living media.
In the middle.
Living media.
I'm grateful. And if your lordships now come to paragraph 5, there are 5 orders.
In living media.
Yes, my lord.
Honorable Apex notes down that standing counsel there pointed out the day-to-day movement of files.
I'm grateful.
Nothing more is explained.
Correct. I'm grateful.
So that is the context.
Now I will deal with judgments which deal with these two judgments. That's what my lords wanted me to tell. Now kindly look at paragraph 5, my lord. There are 5 orders which have been referred to. These are not judgments. These are orders passed. And if your lordship sees, my lords, 13th January 2021 is the first order. The second order is 22nd January 2021. The third is also 22nd January 2021. Fourth is 4th February and 11th January. So these are all orders passed. Now, my lord, I will first show to your lordships. I will just refer 4-5 judgments and then I'm done. Kindly see, my lord, volume 1987, volume 2 SCC 107. And if my lords are kindly please, my lords, to turn to paragraph 3 at page number 2. And on facts, if your lordship sees paragraph 2, it was time barred by 4 days. But the principle has been laid down. My lords have paragraph 3, my lord.
Yes.
The legislature has conferred the power to condone delay by enacting Section 5 of the Indian Limitation Act 1963 in order to enable the courts to do substantial justice to parties by disposing of matters on merits. Would your lordships kindly underline that word? The expression sufficient cause employed by the legislature is adequately elastic to enable courts to apply the law in a meaningful manner which subserves the ends of justice, that being the life purpose for the existence of the institution of courts. It is common knowledge that this court has been making a justifiably liberal approach in matters instituted in this court. But the message does not appear to have percolated down to all other courts in the hierarchy, and such a liberal approach is adopted on principle as it is realized that, but then there are 6 points. Ordinarily, the litigator does not stand to benefit by lodging an appeal late. Refusing to condone delay can result in meritorious matters being thrown out at the very threshold and cause justice being defeated. Like in the present case, my lord, there are two judgments of your lordship's court laying down the issue. As and when delay is condoned, the highest that can happen is that a cause would be decided on merits after hearing the parties. Everyday delay must be explained does not mean that a pedantic approach should be made. Why not every hour's delay, every second's delay? The doctrine must be applied in a rational, common sense, pragmatic manner when substantial justice and technical considerations are pitted against each other. Cause of substantial justice deserves to be preferred, for the other side cannot claim to have a vested right in an injustice being done because of non-deliberate delay. There is no presumption that delay is occasioned deliberately or on account of culpable negligence, on account of malafides. A litigant does not stand to benefit by resorting to delay. In fact, he runs a serious risk. It must be grasped that judiciary is respected, not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice as it is expected to do so. My lord, I will leave it here so far as this judgment is concerned. Would your lordships now kindly have a look at 1998, volume 7 SCC 123, 1998, 7 SCC 123, paragraphs 9 and 10. Paragraph 9 is at, my lord, page 127. My lord, sir, para 9 minutes.
Yes.
It is axiomatic that condonation of delay is a matter of discretion of the court. Section 5 of the Limitation Act does not say that such discretion can be exercised only if the delay is within a certain limit. Well, this line is important. Length of delay is no matter. Acceptability of the explanation is the only criteria. Length of delay is no matter. Acceptability of the explanation is the only criterion. Sometimes delay of the shortest range may be uncondonable due to want of acceptable explanation, whereas in certain cases, delay of a very long range can be condoned as the explanation therefore is satisfactory. Once the court accepts the explanation is as sufficient, it is the result of positive exercise of discretion and normally superior court should not disturb such a finding, much less in a regional jurisdiction, unless the exercise of discretion was on wholly untenable grounds or arbitrary or perverse. But it is a different matter when the first court refuses to condone the delay. In such cases, the superior court will be free to consider the cause shown for the delay afresh, and it is open for the superior courts to come down on the finding untrammeled by the conclusion. This is the reason for such different stance is thus. Lord, this is really important. The primary function of a court is to adjudicate the dispute between the parties and advance substantial justice. The time limit fixed for approaching the court in different situations is not because on the expiry of such time, a bad cause would transfer into a good cause. This is the line. Milord, in this
Paragraph 11 is important.
Milord, may I read paragraph 10 again? 11. Rules of limitation are not meant to destroy the rights of the parties. They are meant to see that parties do not resort to dilatory practices, but seek their remedy promptly. The object of providing a legal remedy is to repair the damage caused by reason of legal injury. The law of limitation fixes a lifespan for such legal remedy for redress of the legal injury so suffered. Time is precious, and wasted time would never revisit. During the efflux of time, newer causes would sprout up, necessitating newer persons to seek legal remedy by approaching the courts. So lifespan must be fixed for each remedy. Unending period for launching the remedy may lead to unending uncertainty and consequential anarchy. The law of limitation is thus founded on public policy. It is enshrined on the maxim, interest republica obsit finis legem. It is for the general welfare of the period that the period be put to litigation. Rules of limitation are not meant to destroy the rights of the parties. They are meant to see parties do not resort to dilatory practices, but seek their remedy promptly. The idea is that every legal remedy must be kept alive for a legislatively fixed period of time.
Then we are referring to paragraph 12.
Paragraph 12. The court knows that refusal to condone delay would result in foreclosing a suitor from putting forth his cause. There is no presumption that delay in approaching the court is always deliberate. The court has held that sufficient cause under Section 5 of the Limitation Act should receive a liberal construction so as to advance substantial justice, vice so-and-so millards, and state of so-and-so. It must be remembered that in every case delay, there can be some lapse on the part of the litigant concerned. That alone is not enough to turn down his plea and shut the door against him if the explanation does not smack of malafides or is not put forth as a dilatory strategy. The court must show utmost consideration to the suitor. But when there is a reasonable ground to think that delay was occasioned by the party deliberately to gain time, then court should lean against acceptance of the explanation. While condoning the delay, the court should not forget the opposite party altogether. It must be borne in mind he is a loser and he would have incurred quite a large litigation expenses. It would be a salutary guideline when courts condone delay due to laches on the part of the applicant. The court shall compensate the opposite party for his loss. In this case, explanation for delay set up by the appellant was found satisfactory to the trial court in exercise of his discretion, and the High Court went wrong in upsetting that finding, more so when the High Court was exercising revisional jurisdiction. Nonetheless, the respondent must be compensated, particularly because the appellant has secured a sum of Rs 50,000 from the delinquent advocate through the Consumer District Forum. They therefore allow these appeals, set aside the impugned order, by restoring the order passed by the trial court, put on a condition that the appellant shall pay a sum of Rs 10,000 to the respondent or deposit in this court within a month. So, my lord, they say compensation is the restitution. Your lordship may now see, my lords, 1988 volume 2 SCC 142. This is Ramagoda. This is a land acquisition matter, my lords. This is Justice Venkatachalya. Paragraph 1, my lord, at page 144. These three appeals by the claimant respondent, in certain cases appeals before the High Court, are preferred by special leave against the common order dated so and so of the High Court of Mysore, Karnataka, condoning under Section 5 of the Limitation Act certain delays on the part of the land acquisition officer in preferring the three corresponding appeals, MFA number so and so, so and so, so and so. Now, my lord, your lordship may straight away come to paragraph 15 at page 148. If my lords are kindly pleased to come to paragraph 15 minutes. Page 148. My lords have it?
Yes.
In litigations to which government is a party, there is yet another aspect which perhaps cannot be ignored. If appeals brought by government are lost for such defaults, no person is individually affected. But what in the ultimate analysis suffers is public interest. The decisions of the government are collective and institutional decisions and do not share the characteristics and decisions of a private individual. The law of limitation is no doubt the same for a private citizen as the government authorities. Government, like any other litigant, must take the responsibility for the acts or omissions of its officers. But a somewhat different complexion is imparted to the matter where government makes out a case where public interest is shown to have suffered owing to the acts of fraud or bad faith on the part of the officers or agents, or where the officers are clearly cross purposes with it. Therefore, in assessing what a particular case constitutes sufficient cause for the purpose of Section 5, it might perhaps be somewhat unrealistic to exclude from the consideration that go into the judicial verdict. These factors are peculiar to the characteristics of the functioning of the government. Government decisions are probably slow and encumbered, as they are by considerable degree of procedural red tape in the process of their making. A certain amount of latitude is therefore not impermissible. It is rightly said that those who bear the responsibility of the government must have a little play in the joints. Due recognition of these limitations on government functioning, of course within a reasonable time, is necessary if the judicial approach is not to be rendered unrealistic. It would perhaps be unfair and unrealistic to put the government and private parties on the same footing in all respect in such matters. Implicit in the very nature of governmental functioning is procedural delay incidental to the decision-making process. In the opinion of the High Court, the conduct of the law officers of the government placed by the government are in a predicament, and it is one of those cases where so and so was not imputed to the government. It relied upon and trusted its law officers. Lindley MR and so observed, though in a different context, business cannot be carried out on the principles of distrust. Men in responsible positions must be trusted by those above them. In the opinion of the High Court, it took quite some time for the government to realize so and so. So this is the principle where they say that government cases have to be looked at in a different way. Now the next judgment is, my lord, 1996, volume 3, SCC 132. My lord, here there was a delay of 109 days. And that your lordships will find at paragraph 2, page 134. My lords may now kindly turn to paragraph 11 at page 138. My lords have para 11. My lords have para 11. My lords?
Yes.
Yes. It is notorious and common knowledge that delay in more than 60% of the cases filed in this court, be it private party or the state government, are barred by limitation, and this court generally adopts a liberal principle in condonation of delay, finding somewhat sufficient cause to decide the appeal on merits. It is equally common knowledge that litigants, including the state, are accorded the same treatment, and the law is administered in an even-handed manner. when the state is an applicant praying for condonation of delay, it is common knowledge that on account of impersonal machinery and inherited bureaucratic methodology imbued with the note-making, file-pushing, passing on the buck ethos, delay on the part of the state is less difficult to understand, though more difficult to approve. But the state represents collective cause of the community. It is axiomatic that decisions are taken by officers, agencies, probably at a slow pace, an encumbered process of pushing files from table to table, keeping it on a table for a considerable time of delay, intentional or otherwise, is a routine. Considerable delay of procedural red tape in the process of their making a decision is a common feature. Therefore, certain amount of latitude is not impermissible. If the appeals brought by the state are lost for such default, no person is individually affected, but what in the ultimate analysis suffers is public interest. The expression sufficient cause should therefore be considered with pragmatism in a justice-oriented approach rather than the technical detention of sufficient cause for explaining every day's delay. The factors which are particular and characterized in the functioning of the government conditions would be cognizant to require the adoption of a pragmatic approach in a justice-oriented process. The court, this next line, if your lordship don't mind, your lordship may kindly underline.
Yes.
The court should decide the matters on merits unless the case is hopelessly without merit. That's the point. No separate standards to determine the cause laid by the state vis-a-vis the private litigant could be laid to prove strict standard of sufficient cause. The government at appropriate level should constitute, etc. Your lordship may leave all that.
Yes.
And then they condone the delay of 109 days. The next judgment.
In para 10.
Para 10, I'm sorry.
The lordships have referred to another.
In schedule. Para 10, my lord?
Correct.
Yes, may I read that?
Scheduled case.
In scheduled case, so and so, a bunch of held that the bona fides of the parties are to be tested on the merits of the delay. I'm grateful, merits of so and so to so and so was not condoned on the ground that the parties approached the court after the decision on merits was allowed in other cases by this court. Therefore, it was held that it did not. Yes.
If in any other case you have not preferred or you have kept silent.
Yes.
But this case you have picked up one amongst them and.
No, here, let me tell you what happened. Let me tell you what. Now, this case was rendered, and subsequently there are two judgments. There are two judgments. That is what your lordships are telling me, that you came because there were two judgments. The submission I'm trying to make to your lordship is that if your lordships have settled the law, if merits have been decided, and I am approaching your lordships for a relief which is based in law, then delay will not defeat that decision to be decided on merits.
Substantial.
I'm sure, for that, my lord, I showed your lordships that first judgment of the Supreme Court, where 800 days was delayed, because after the High Court judgment, the law was laid to rest by the apex court. I will deal with that at the end.
Possibly what my lord is saying.
Yes, my lord.
That suppose there are 30 cases.
Yes, my lord.
You don't prefer appeal against 20 of the orders and you implement them.
Yes.
And then you challenge other 10 orders.
Yes. Yes. Well, let me straight away answer this question. Well, let us say if the first 10 cases were implemented when the law was not decided. When the law was not decided.
No, if the law is decided.
No, if the law is decided, my lord.
If law is decided.
Yes, my lord.
And based on that decided law.
Yes, yes.
See.
I implement.
A single judge.
Yes.
You implement.
Fair enough. I implement.
And later.
Yes.
You challenge.
Yes.
10 of the other orders.
Correct. Now, my lord, the question is, if I might put it differently, that the question is whether parity is to be maintained in all the cases. In all the
if I may put it like
yes, yes,
yes. Just hinting at this point, this
correct,
case.
Correct.
Joseph Barry case you are relying upon.
Right.
It has come recently.
Yes, ma'am.
But prior to this,
yes,
Joseph Barry, many other cases have come up on the similar issue of
Yes.
similar.
Yes, yes,
And you have implemented that,
yes.
which is the reverse
Correct.
of Joseph Bari.
Correct, correct. Possible.
So
Possible.
those cases we have kept as such
Yes.
and implemented.
Yes. Your lordships.
So parties have got benefits.
So therefore,
Now when Joseph Bari case.
yes.
have
So
decided.
therefore, what we are really speaking about is negative equality. Somebody has got a benefit, the other man is deprived of the benefit. Right? So therefore, my lords, Article 14 does not countenance negative equality. And if your lordships want, I cite those judgments. I have, in fact, one judgment of Anup Senapati with me, where this very question arose. Your lordships are hearing one matter regarding that GIA order 2004. So what was argued before the Supreme Court was this, that many people have got benefit under this GIA 1994. What is 2004, my lords? 1994, one GIA was made giving granting aid. In 2004, it was repealed. The law was settled in 2019. Well, kindly visualize. Under a repealed act, people got benefit from 2004 till 2019. 15 years. One of your lordships sitting in single decided that how can somebody get the benefit of a granting aid which stands repealed since 1995, 1994, 2004. Then the matter went to the Supreme Court. That is when Anup Senapati was decided to say that because this rule stood repealed in 2004, no one can get any more benefit under the said rules. But it was argued that after 2004, you have given to so many people. So why will you not give it to us? So they said that there is no concept of negative equality. If somebody has been wrongly benefited, it does not mean that the same wrong benefit would continue to the others.
Here, is there any prejudice caused to the state?
Well, the prejudice is this.
Suppose
yes,
you take the sealed cover proceeding.
Yes.
And the criminal case or the disciplinary proceeding is protracted.
Yes.
Somehow or other.
Well, the prejudice, I would submit
So
this.
ultimately,
Yes.
if he is convicted or disciplinary proceeding is held against him,
But
then you can recover the amount.
Yes, but that's not the
He's
point.
not fleeing away from
the point really
clutches
is,
of the
the point
state.
really is, Miller, the point really is this. What is the law that your lordships have to decide? Your lordships did not decide in both these cases that he can continue to get the promotion, and in the event he loses either in one of those two cases, he doesn't succeed in both, then he will be returned, he'll be required to refund. That your lordship did not decide. On the contrary, your lordships decided in two division bench judgments that if there is a departmental inquiry pending or if there is a criminal case pending, then in such cases, keep it in sealed cover. You can't grant him promotion.
No, I am on substantial justice.
Yes, sir. No, no.
If it is technical consideration and substantial justice.
It is not technical. It is substantial.
Yes.
It is substantial. Your lordships have laid down the law that one is not entitled.
So your submission would be
Yes, my lords.
that decision is because of the statutory provision.
Exactly. My lord, under your lordships, basing on the rules, have come to the conclusion that in both these judgments, that the sealed cover cannot be opened till such time both the proceedings are over. If that is good law, my lords, then there is no question of giving the benefit that has been given under the impugned order. That's the point. Now, that is my submission.
All right. Yes.
So, my lord, now kindly see, my lords, the next judgment is 2023-10 SCC 531. My lord, here there was a delay of 479 days.
Yes.
That your lordships will get, my lords, at paragraph 1. And the issue is, my lord, just after that, paragraph 2, the limited issue that we are asked to decide is whether the High Court was justified in condoning delay in presentation of the appeal. In the process, we need to necessarily consider whether the first respondent had shown sufficient cause for which the appeal could not be presented within the time prescribed period of limitation. Under paragraph 4, after considering the pleadings as well as other materials on record, the High Court was satisfied that the first respondent of the appellant had shown sufficient cause for which it could not present the appeal within the time. Hence, by its impugned order, it proceeded to allow so and so. The delay of 479 days in presentation of the appeal was condoned, but not without the High Court imposing a cost of 10,000 on the respondents. Well, I will not trouble your lordships with the contentions. Kindly come to paragraph 16 at page 537.
Yes.
The learned senior counsel for both the parties invited our attention to the various decisions of this court, which we propose to consider hereafter. In Collector versus so-and-so, the relevant High Court did not condone the delay of 4 days on presentation of the appeal by the collector in the land acquisition matter for which the order rejecting the application under Section 5 of the Limitation Act was carried in appeal. But Kadji is the one I cited first.
Yes, you cited.
I have cited. So just after that first paragraph, my lord, see a few quoted paragraphs. And such liberal approach is adopted as a principle as it is realized when substantial injustice and technical considerations. Paragraph 4, my lord, when substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred. On the other side, side cannot claim to have any vested right in injustice being done because of the non-deliberate delay. It must be grasped that judiciary is respected. Not only your lordships have seen all that.
Yes.
Now, let us see paragraph 18. State of Nagaland versus Lipok arose out of an appeal where this court condoned the delay of 57 days in applying grant of leave to leave appeal. This court observed that in cases where substantial justice and a technical approach are pitted against each other, a pragmatic approach would have to be taken with the former being preferred. Further, this court noted that what counted was indeed the sufficiency of the cause of delay and not the length of the delay, where shortness of the delay would be considered. When using extraordinary discretion to condone the delay would be condone the same. This court went on to record that court should attempt to decide case on merits. Kindly underline that. This court went on to record that court should attempt to decide a case on its own merits unless the same is hopelessly without merit. My lords may kindly underline these words. It is also observed that it would be improper to put the state on the same footing as an individual since it was impersonal machinery operating through its officers. Now your lordship may skip Balwant Singh and come to para 21. This is Postmaster General, which has been referred to by the earlier judgment. In Postmaster General versus so-and-so, this court noted that in case where no negligence, deliberate inaction, or lack of bona fide, a liberal concession ought to be adopted to render substantial justice. But on the facts before the court, the appellant could not take advantage of the earlier decisions of this court. Further, merely because the state was involved, no different metric for condonation of delay could be applied to it. Importantly, it noted that the appellant department had offered no proper and cogent explanation for this court for condonation of a huge delay of 420 days, apart from simply mentioning various dates. The claim on account of impersonal machinery and inherited bureaucratic methodology of making the file notes, it was held not acceptable in view of the modern technologies being used and available, and also holding that the law of limitation undoubtedly binds everybody, including the government. This court went on to the prayer for condonation. Your lordship may now kindly turn to paragraph 23. A bench of 3 honorable judges of this court in state of Manipur versus so-and-so had faced with a delay of 312 days, being the state in preferring the first appeal. The court, on grounds of public interest and impersonal nature of governments and ramification of individual errors on the state, condoned the delay in filing the appeal on payment of rupees so-and-so. Now your lordship may see, my lords, that G. Ramagoda versus LAO.
Yes.
Ramagoda.
we just now.
We have seen, the lordships have seen Ramagoda. 29.
Yes.
Now kindly come to para 29, my lord. This is the analysis. After seeing all the precedents, we have heard Mr. So-and-so and Mr. So-and-so appearing for the appellants and the respondents. Considering the aforementioned judgments, there cannot be any quarrel that this court has stepped in to ensure that substantive rights of private parties and the state are not defeated at the threshold simply due to technical considerations of delay. However, these decisions notwithstanding, we reiterate that condemnation of delay being a discretionary power available to the courts, exercise of discretion must necessarily depend upon the sufficiency of the cause shown and the degree of acceptability of this explanation, the length of the delay being immaterial. Sometimes, due to want of sufficient cause being shown or an acceptable explanation being offered, delay of the shortest range may not be condoned, whereas in certain cases, delay of long periods can be condoned if the explanation is satisfactory and acceptable. Of course, the court must distinguish between the explanation and excuse. An explanation is designed to give someone all the facts and lay out the cause for something. It helps to clarify the circumstances of a particular event and allow a person to point out something that has happened is not his fault. It is really not his fault. Care must, however, be taken to distinguish an explanation and an excuse, though people tend to see explanation and excuse as the same thing and struggle to find out what is the difference. Your lordship may now see para 34. The order under challenge, my lordships have it 34?
Yes.
The order under challenge in this appeal is dated so-and-so. It was rendered at a point of time when the decision of so-and-so were holding the field. It is not that the said decisions do not hold the field now, being overruled by any subsequent decision. Although there have been some decisions in the recent past, state of MP Behrulal is one such decision. Apart from University of Delhi, which have not accepted the government lethargy, tardiness, and indolence in presenting appeals within the time as sufficient cause for condemnation of delay, yet the exercise of discretion by the High Court has to be tested on the anvil of liberal and justice-oriented approach expounded in the aforesaid decisions which have been referred to above. Well, may I read this again? Because the previous judgment referred to Behrulal. Behrulal is what was referred to.
The Supreme Court says that 1987 judgment and 88 judgment, they still hold the field.
I'm grateful.
They having not been over.
I'm grateful. We find that the High Court in the present case has assigned the following reasons in support of its order.
Would you now mean to say that the Behrulal now has to be construed in its own
facts,
context?
In its own facts. As the lordship said, that Behrulal was on a day-to-date basis. Some explanations were not given. But ultimately what they say is, my lords, the approach should be justice-oriented. Ultimately the test is, my lords, that it should be based on merits and in public interest.
And 35.4.
35.4. Let me read 35, all of 35. We find that the High Court in the present case has assigned the following reasons. The law of limitation was founded on policy and on some lapse on the part of the litigant itself would not be sufficient to deny condonation of delay. The expression sufficient cause is elastic for the courts to do substantial justice. May read 35.4. Further, a distinction should be between inordinate, unexplained, and explained delay. When the present case, the first respondent sufficiently explained the delay on account of negligence on the part of the government functionaries and government counsel on record. Lordship may see, my lords, 36. Given these reasons, we do not consider that the discretion have to be exercised by the High Court in an arbitrary manner. The order under challenge had to be clearly wrong order so as to be liable for interference, which is not the case here. It is now time to distinguish the two decisions, Sharma, Elivary, and so and so. Balwant Singh arose out of a landlord tenant, but I will not go there.
It may come down to one thing that any number of days of delay or years of delay, inordinate delay.
On the one
has
side,
has to be seen in the perspective of sufficiency of cause.
sufficiency of cause, ends of
Explain,
justice,
Sufficiently explained.
ends of justice and merit, and a justice-oriented approach.
Sufficiently explained.
Explained, and also they say, my lord, justice-oriented approach. They say justice-oriented approach and merit. And I will straight away give you lordships an example of this. If your lordship sees that order, which I had handed over in the beginning. But there is one more judgment. This is 2023 SCC online, 977.
No, we can think that suppose.
Yes, ma'am.
There has been inordinate delay of 10 years.
My lord.
In preferring an appeal.
Yes.
And the order which is under challenge.
Yes.
Is so obnoxious.
Yes.
And contrary to law.
Correct, ma'am.
That cannot be allowed to operate.
Yes, ma'am.
It's a different matter if the order has taken effect too and it's
Already complied.
It's a different matter.
Correct.
But in such circumstance,
if it shocks your lordship's conscience.
Yes, that there can be circumstances.
Fair
So, though there cannot be any watertight formula.
Correct.
Laying down in what circumstance the court, it is left to the discretion of the court based on facts and circumstances of each case.
Yes.
The court is to condone the delay or refuse to.
That is why in one judgment your lordship saw play in the joints.
So in many of the cases, we have condoned the delay.
Yes, ma'am.
Because there was no merit.
Your lordships have condoned the delay always if your lordships have found merit.
No. In many of the cases, we condoned the delay because even otherwise there was no merit.
And your lordship, my lord, Supreme Court says delay condoned, SLP dismissed.
Yes. So, yes.
Now, your lordship may see, my lord, in this one, para 12, this is a recent judgment. Here there was a delay of 564 days. This is a case which went from Orissa. BDA, Bhubaneswar Development Authority.
Yes.
Para 12, a writ appeal was filed against the order of the learned single judge with a delay on 564 days. The division bench, by its impugned judgment dated so and so, declined to condone the delay. The court held that the reasons for delay provided by the appellant did not constitute sufficient cause. Consequently, the writ appeal was dismissed. Your lordship may now see para 14. We have perused the reasons which were placed on record of the division bench for condoning the delay. The state explained in detail steps which were taken, necessary approvals for the purpose of processing the writ appeal. Besides, declining to condone the delay in case will have serious consequences of allowing an impostor to continue having the benefit of a reserved seat. Somebody has wrongly, as it fell from your lordship. Here somebody was holding on to a reserved seat. This is not just a matter of detriment to the state, but to the genuine aspirants to the reserve post, which would be ousted. We are of the considered view that the division bench ought to have condoned the delay in the facts of this case. So where your lordships are seeing that injustice is being perpetrated, merits are being compromised, in such cases, your lordships have normally tended to condone the delay. My lord, I will show your lordships again that
So
judgment.
therefore,
yes, my lord.
These judgments also indicate one aspect.
My lord.
That if an application or appeal is time barred.
My lord.
While considering an application for condoning the delay.
My lord.
The court is also required.
I am grateful.
To see the legality.
I'm not.
Of course, on prima facie, legality, consequences.
Consequences, merit.
Merit. So it should touch upon that also.
Yes, my lord, my submission.
Where the delay is substantial. Where the delay is substantial, then particularly in such cases, the court should see the merits of the of the appeal. What is the?
I'm grateful.
Those aspects should be seen. It is not that, first of all, you deal with the with the application for seeking condonation or delay, and if it is not, then dismiss it.
Correct.
No question of entering into the merits.
My lord, sufficient cause, one of the major ingredients would be merit. Merit is also one of the facets.
Sufficient cause is cause, which prevented you from filing
Correct.
the appeal or whatever within time. That is the sufficient cause.
But the merit also your lordships have to consider.
Merit we consider to exercise the discretion.
I'm grateful. Your lordships have put it so nicely, my lords. Your lordships have put it so nicely that when your lordships are going to exercise discretion, merit is one of the relevant considerations, and also ends of justice is also a relevant consideration. So in my humble submission, my lords, that this is a fit case where limitation should be condoned, failing which, if your lordship would not exercise its discretion, it would be negating the law laid down by your lordships in 2 division bench judgments of this court.
The prejudice aspect which I was...
Yes.
Perhaps para 22 of this BDA judgment.
BDA judgment, yes, perhaps.
Para 22.
Yes, perhaps.
Perhaps that is the indication.
This court has further held granting protection to individuals who are eligible to the post has a deleterious effect on good governance, allows an ineligible person to give access to a scarce public resource, violates the rights of eligible persons, and perpetuates illegality of unduly besting benefits on an ineligible person.
So these are the considerations which weighed in the minds of perhaps. I'm not so sure.
It did.
So the prejudice aspect which I
posed. Yes.
So this is the indication.
This is.
Which the honorable.
This is. And my lord, our rules also say this. My lord, our circular, GA department circular also says so. If your lordship sees Annexure 3 series page 22. Page 22, my lord, of the writ appeal. This is the office memorandum of 18th February 1994.
Sealed cover procedure.
I'm grateful. And if your lordship says
of
6.
The year 1994.
1994, 18th February 1994. And paragraph 6, his interest is completely protected. His interest is completely protected. And my lord, may I read this? On the conclusion of the, my lords have it, on the conclusion of the disciplinary case, criminal prosecution, the sealed cover or covers shall be opened. In case the officer is completely exonerated, the due date of his promotion will be determined with reference to the findings of the screening committee, kept in the sealed cover, and with reference to the date of promotion of his next junior. On the basis of such finding, the government servant may be promoted if necessary by reverting his junior most officiating persons. He may be promoted notionally with reference to the date of promotion of his junior. In cases of complete exoneration, the officer will also be paid areas of salary and allowances. In other cases, the question of areas will be decided by the state government. So his interest is fully protected. I'm grateful to your lordship.
My lord, may I kindly glance at the flag number B, my lord. The IF for condonation of delay.
Yes.
The explanation given by
yes,
the...
Mr. Dr. While deciding the issue,
my lord,
we may also direct.
Yes, ma'am.
If we are inclined to condone the delay,
my lord,
that when we record,
my lord,
that the delay has not been fully explained,
my lord,
but because of the nature of order, we are inclined to
condone
the delay.
I'm grateful.
In all such cases,
my lords,
we will not direct, but we will give the state government liberty to initiate action,
my lord,
against the person involved, person responsible for delay, one, And two, we may impose appropriate costs also. If we
To be recovered from the delinquent
we
officers.
will give you that liberty. We will not direct, we will again
Yes.
give you that liberty, give the state government concerned officials liberty to recover the amount.
My lord.
That we can do in appropriate.
My lord, if your lordship don't mind, my lord, your lordship may say the state government will recover.
No,
It will help us in reducing all these.
No, we should not say, because that will amount to direction to the state government.
Your lordship may leave it at that. Your lordship may leave it at that.
Therefore, that liberty the state
I'm
government
grateful.
should have. In
I'm
appropriate cases.
I'm grateful.
There may be cases where, because of circumstances, the
So
could not-
I'm grateful for both
whatever law we will be laying down, it is not only for the purpose of intra-court appeal.
Yes, yes.
It will be dealing with
For everything.
so many things.
My lord, we break our head in our office half the time for this. Delay in filing SLP, delay in filing writ appeal.
Yes, let us see what happens.
I'm grateful.
Flag B, my lord. Page 2, my lord.
Yes.
The IN number 2585, which is the application for continuation.
Your objection.
No, the application, the IN. Flag B. My lord,
We can understand. We know the submission which you are going to make, that there is no explanation.
my lord, the order was passed on 20th January 2022. Thereafter, content proceeding was initiated, first content. Thereafter, second content proceeding was initiated. Now, what I'm submitting is that after passing of the order, it is not like that the state governments are not been informed about the orders. After filing of the cases, we have to serve a copy on them. At the time of admission, the state councils, along with the copy of the petition, are there during the hearing of the cases. And all the orders have been passed in their presence. Therefore, the stand taken that.
No, we appreciate.
And another thing is that they have completely put the blame on the government servants, where they themselves have not stated when they have communicated the order for filing of the writ
At the
appeal.
time of contempt also, they know that.
They know that. Apart
They are
from that,
aware.
apart from that also, they have not stated in this IA when they have communicated or asked the government of the law department or the concerned department to prefer an appeal. That
You
date
are
they have not.
making, you are
That is there on record. I'm not making allegation. And this is my submission. They've only stated that the government in the law department has accorded sanction on 16th December 2022. Thereafter, on 23rd of February 2023, the Office of the Advocate General was entrusted with the file to file the writ appeal. Thereafter also, the writ appeal was filed on 15th of May. I've also annexed the case details, my lord, obtained from the website, which is at page 6, my lord. So that is one
who
part.
is to be blamed?
That is, my lord, is to be decided.
No. You tell us. Who is to be blamed? The appellant. Who is the appellant?
The state.
So it is your state also. So therefore, the plea which you are taking, that the state government may consider, may think of.
And another thing, my lord,
but we have not decided that we are going to allow their limitation petition. We shall decide that later, but still make your submission.
That is one submission.
Yes.
They have not stated the plausible explanation as to why there was such a delay.
Yeah.
Even if the file was entrusted on 23rd of February,
Yeah.
still there was a more than 2.5 months delay in filing the writ.
Please don't make that submission. I would suggest further.
Oh, please.
Don't make that because that goes in favor of the state. That submission is in favor of the state. That state had taken a decision. State had entrusted. So that's a kind of explanation also.
But
for the state,
that entrustment was given after 1.5 years.
That
is what I'm drawing to my lords.
At the time of execution, they could implementation.
After filing of the second
understand that it is not implementable. It may be against the law. So at that time they have taken a decision.
We will
come up.
see
that
whatever observation we have made, those are tentative in nature. we shall be finally deciding the matter after the judgment comes. So
Thereafter, my lord, I have annexed
so
the,
you should not carry this impression that we have decided to condone the delay and we have
no,
we
my
will
lord, I
continue.
have not carried that impression.
Yes.
Thereafter, my lord, Annexure B, my lord, page 7, the order passed in Surma Manjari case, my lord. I will read out the paragraph, some paragraphs of this.
Order passed in Surma Manjari was in a writ proceeding. So where is the limitation prescribed?
That is there in paragraph 4, my lord.
Where is the limitation prescribed? What is the period of limitation?
In
filing writ petition against an order passed by the administrative tribunal, where is the limitation prescribed?
There is no space, there is no, but generally it is
Chandra Kumar lays down some.
Generally it is held to be 1 year in my limited.
We don't remember the, I read L. Chandra Kumar when it was first reported. Thereafter, I have not reported, but I have not read. Does that judgment lay down any this thing, prescribe any
Limitation to
time?
Challenge the administrative tribunal's order before the High Court.
If there is no limitation, then in Surma Manjari, the court had no occasion to deal with this aspect. Because for writ petition, there is no limitation prescribed. Laches, on the ground of laches, the writ petition was dismissed. But again, we would suggest, we advise you to, we will examine it, whether in L. Chandra Kumar some time limit has been laid down or not.
As per my limited
Even you can-
instruction, limited knowledge, it is 1 year. As per my limited knowledge.
Maybe.
For writ petitions.
For writ petition against the order of the tribunals.
From where you get?
That I will
Under
assist
Article
my.
226, there is no prohibition.
Under Article 226, even 2 days delay can be considered to be laches. Even 5 years may not be considered. There is no limitation period prescribed. So in Surma Manjari, apart from the question of laches, limitation question was not at all involved.
Paragraph 4, may I place that? Paragraph 4 of the order.
Paragraph 4 you can place, but for what?
So
what
as per
purpose?
that Honorable Supreme Court latest judgment, this Bhirulal case.
Yes, ma'am.
Bhirulal case has been referred to in the judgment. The Advocate General has read to this court.
The copy of the judgments relying on was not served on. Neither the note of citations.
So there, Bhirulal case was confined to, as if it is confined to that context.
May I place that, ma'am? Paragraph 4. If my lordship permits.
Paragraph 4, Supreme Court made it clear.
The Supreme Court has made it clear in a series of judgments, including the recent decision in the state of Madhya Pradesh versus Verulal, such and such, that there have to be a proper and convincing reasons for the delay in the state authorities filing appeals or petitions. In the said decision, the Supreme Court observed as under paragraph 2, madam. We are constrained to pen down a detailed order as it appears that all our counseling to government and government authorities have fallen
That
on
we
deaf.
have seen, Mr. You are not required to, that Berulal has been considered.
And thereafter, they have stated that in this third paragraph towards the last, this portion is more.
Berulal, Mr. Counsel, has been considered in the subsequent decision in 2023. We will see what can be done.
If my lordship permits, then I can file a memo of citations.
Yes,
within
yes,
by
surely.
tomorrow.
Sure, that will help us to do it by tomorrow.
By tomorrow.
Representing the state of Odisha and London counsel appearing on behalf of the sole opposite party. Anyone?
Yes, ma'am. Sole respondent.
On the point of limitation.
In IA number?
IA number so IA number. Stop.
2585.
2585.
This matter for orders on the point of limitation on 25th of June. Sorry, in 19th of June. 19th of it's going on. You are here or you are-
I may be permitted to file the memo of citations by.
Yes, yes. Do it by tomorrow.
By tomorrow.
Or
Monday.
do it by tomorrow, not Monday.
By tomorrow. Obviously.
And we assure you that we shall consider whatever citations you give that to us.
Have some research also.
Yes, my lord.
Matter fixed for 2 p.m. hearing, item 41.
May I please to ask? Yes, sir. In this matter, I am against the order dated 10/12/2021 under Annexure 1, against which 2 other writ appeals are pending, which has also been connected to this.
Just a minute. Yes.
Yes, in this case, the disputed property.
There are huge delay, my lord. You will also take up this delay matter first so that it will be tagged together. It has come for convenience of my lord. But his application, my lord, if you also see the limitation petition, it was within his knowledge 2 years.
I confirm my lord, that delay I have filed an application. I was not a party in the writ petition. When I came to know about the writ petition, immediately I filed a recall petition in that writ petition.
Where is your application?
Yes.
For condonation on delay. Where is your application for condonation of delay?
Condonation of delay application. File guys.
Yes.
Let's see. Fact C, it is at fact C, my lords.
Yes.
The appellant petitioners filed the above mentioned writ appeal challenging the order dated 10/12/2021 of the Honorable Single Judge in WPC number such and such under Annexure 1. The appellant petitioner, being the legal heir of the recorded owners of the land, is a necessary party to the writ petition. The respondent number 1 had intentionally filed the above writ petition without including the interested person recorded in the Hall Settlement Aurora in respect of the disputed land.
Just a minute. So all right, when you filed your IA for recalling.
Yes, I filed a IA for recalling the order.
When?
That is under annexure. That is I number 3383 of 2022 under annexure 11. That I filed with the time.
Yes.
Under annexure 11 at page 107. That was filed on 10/3/2022.
Yes. Then what happened?
I also filed an intervention application because I was not made a party in that WPC.
Where?
That is annexure 12.
This order dated 10/12/2021 was filed in which order? Which case?
2569. That WPC number 25695 of 2021. In that case, the present order on the challenge, that is 10/12/2021, was passed. When I came to know about this order, I filed the IR number 3383 of 2022 for recalling that order. And since I was not made a party in that case, I also filed a petition under a petition IR number 6253 of 2023. Sorry. That is 3382 of 2022 at page 103 Annex 10. I filed an intervention application.
In which case?
In that WPC.
The WPC was disposed of.
Disposed of. I filed a petition for recalling that order, and also I filed a petition for intervention.
Where was the question of your intervention?
That is the mistake for which the delay. But I was pursuing when the matter came to my notice. I started pursuing. That is the reason. But thereafter, I came to know about the writ appeals.
Writ appeal filed by whom?
One by state and another by a private person. When I came to know about the writ appeals, that is, the state has filed 226 of 2022. In that also, I filed a interim application number 6253.
Yes.
For intervention that I may be heard. At that stage, my lords, I realized that unless I file an independent writ appeal, my facts cannot be placed before this honorable court because it was not in the writ petition. That's why I filed.
But you filed this in 2024.
Kumel, I know that it delay for 820 days. I don't dispute that.
Yes.
But my submission before your lordship is that when the matter came to my notice, maybe under the wrong advice or a wrong impression, I am pursuing the matter, but not in the appropriate forum. And since the matter is already pending before this honorable court.
Did you file your intervention application also in this WA?
Yes, in the other writ application.
In
Writ appeal number 226 of 2022.
you have filed
Yes, I have also filed.
intervention application.
So I fully submit before your lordship that there is 20 days delay in filing the writ appeal. But it is not deliberate because I am pursuing the matter constantly. Only thing that unless my writ appeal is admitted, the documents which are not brought before the honorable single judge, though in the earlier writ application, the present respondent number 1 had categorically admitted in Annex 3, that a document I have annexed, that this land was leased out to me.
See, you had two options. You have not exhausted any. You could have filed a review application. Seeking review of that order. You could have sought recall of that order by filing separate writ application. You did not do that.
I'm sorry, my lord, I know.
How can you challenge this order now?
That's why I filed a leave
And that
petition.
too, how can you bring on record those facts which are not available before the learned single judge to assail the order passed by learned single judge?
That is the reason. I brought these facts to the notice of this honorable court that in the
But the procedure cannot be allowed.
I can file an writ application, but since the writ appeals are pending before this honorable court.
Writ appeals are pending, will be pending. The writ appeals are pending against the order.
Yes, ma'am.
Which has been passed by the learned single judge. According to you, you were not heard, you were not made party, you were necessary party.
Understood.
So there is a Supreme Court decision direct that you can file a petition.
Press writ petition.
Or you will review application, seek review of the order. There you may claim, you may take all this plea that.
In that case, I filed a recall application, not a review application.
Recall application, nothing. Recall application How can?
But since the matter is sub judice before this honorable
The,
court.
the matter is not sub judice. The writ appeal is, see, in this writ appeal, an order is under challenge. And the order has been passed behind your back according to you. Because you are not implemented party. You can seek review or recall or whatever. But you cannot challenge the order, bringing or record certain documents which are not there before the in the writ proceedings. How can we say that the order of the learned single judge is incorrect? Because this.
What I am submitting, my lords, if this honorable court decides the writ appeal against the present appellants, immediately that document will be registered and the property, he will take out the property proceeding.
Difficult, very difficult. We will allow, we will not allow, what we will do, we don't know.
That is the problem. That's why I want to submit.
Therefore, you should have filed that application. Now, it's very difficult to entertain your appeal.
But
and have you been granted leave?
No, unless the delay is condoned, your lords may not grant leave. Only one thing.
A person who was not a party in the writ proceeding, how can he prefer?
No, I have filed a leave petition.
Leave petition we will have to reject.
The reason, my lords, if your lords permit, so far delay is concerned, your lordship knows that when a matter is pursuing a matter on bona fide mistake, he may be granted leave to contest because the matter has not yet been decided.
That will not be a proper practice.
Just to recapitulate your lordship's memory, this is that case which your lordship has already had extensive. That is a judgment of the Honorable Apex Court, and by virtue of that Apex Court judgment, the petitioner before the writ court wanted to take some benefit. And that judgment of the Honorable Apex Court, there is no plot number, khata number, so and so, no description. And he is a person who is claiming that I am in possession of that particular land. So without implementing me as a party, the writ petitioner has obtained the order from the Honorable Single Judge. And what I find in the counter affidavit filed by the state government before the Honorable Single Judge, I may be permitted to place only one para from the counter affidavit, which is available at page 109 of the writ appeal. I have specifically, the state government has specifically said that this Jyotish Chandra Datta is a necessary party, and without implementing him, the petitioner should not entitled to prosecute the case, and the petition is liable to be dismissed for non-joinder of this plea we have taken in the counter affidavit, and this has not been taken into consideration in the interim judgment. That is a fact. But we have had intimated that now the person after the judgment, simultaneously he filed a recall petition before the Honorable Single Judge and thereafter filed this writ appeal with leave to appeal after a belated stage. He wants to point out that, and another private person has also filed the appeal, and your lordship has already granted him leave to appeal, with the same objective, that this property which he now wants to transfer, this is not covered in the document. On that day, your lordship asked me whether your counter affidavit reflects these things. But what I fairly submitted before your lordship, that in our counter affidavit, there is no such clear and unambiguous statement, and which they wanted to point out for effective adjudication. This is the fact. In these circumstances, he has filed the appeal. He is in possession. That is also admitted in my counter affidavit filed before, and that is why I said I take a very specific stand before the writ court that he is a necessary party. Without implementing him, the writ is liable to be dismissed for non-joinder of this.
In all other writ petition, I have annexed it.
And yes, in other writ petitions filed by him,
he has attested that I have taken the property on lease, and he has implemented me as a party in that earlier writ petition. But in the present case, he has not implemented me as a party. I have filed documents that since 1923, I am in continuous possession on lease from the stream.
Your documents we cannot rely on. We can rely on only such documents which were there before, and such pleadings which were there before the learned single judge.
In that also,
so whether your counter affidavit was replied when the rejoinder was filed,
Para
your
70.
counter affidavit. filed in the.
Yes, there is no rejoinder filed by.
Huh?
There is no rejoinder filed by the petitioner to that counter affidavit.
That someone is in occupation.
I'm just placing, only take 2 minutes. That it is humbly, this is paragraph 17 of my counter.
No, not your counter. Whether any reply was filed by the petitioner.
To this counter affidavit.
Yes.
No,
But
he has
my
not.
consistent stand is, this Jyotish Chandra Datta is not an.
No, this affirmation has not been denied.
Just a minute. It was from very beginning, I have been saying that he was my caretaker. This lease was never, he has fraudulently obtained it, and the lease deed also, the schedule also doesn't match with my property.
All right.
My property is different.
We will take up this matter soon before the vacation begins.
My lord, it may be posted after vacation. After vacation.
Because the observation of apex court is there for early disposal, my lord, because 72 lakhs towards the insurance.
All right, we will decide right now. Yes, so this is specific stand was taken by you.
Yes, my lord. Not denied by him. That he is a necessary party.
Not denied, and the petition has been
Disposed.
So
we
can remand the matter back.
Yes, that is what only. That your lordship is correct in saying that since the material now produced by him was not before the honorable single judge, so we cannot find any fault in the impugned judgment. But if this evidence which now he is producing appears to be substantive, or
maybe we don't know.
Yes.
My lord, my land senior is arguing this matter. State and municipality are fighting each other in the civil court. With regard to title.
He has made his submissions. Now you make your submissions. He says that he was a necessary party. You did not impede person who was necessary party.
I can show from the documents filed by my land senior, Mr. Mahapatra.
No, his appeal we are not hearing. We will hear the appeal filed by the state only.
Yes, because my submission, because it is a certiorari writ, I am challenging the order of a quasi-judicial authority. Only the person who are involved therein are necessary party as per the High Court rules. No. I can't make any other persons as a party, because even if he claims title over the property, my lord, I can't get a title by virtue of a registered document.
All right.
Merely because the registration is there. That is
My lord, I am the appellant. Myself, Mr.
Just a minute. Just a minute. So your submission is over.
No, I have no.
On the point of
non-joinder.
Only
necessary party, your submission is over. Whether your submission is over on the point of non-joinder of
the records, whether rejoinder was filed or not, I don't remember exactly.
But the impugned judgment reveals no rejoinder is filed.
But my contention was there in the court below that.
All right, we will see whether rejoinder was filed or not.
There is no rejoinder. There is no recording with regard to his so-called.
Mister, you are causing delay in disposal of the.
No, Lord, I have no intention. I have rather only thing will rejoinder was filed or not.
My lord, I am the appellant, Jagannath Bastia.
Please wait.
That your lordship can check it from the impugned judgment. No rejoinder.
Rejoinder was filed
Filed.
by the petitioner in the writ 25695 of 2021.
The copy is not.
There two documents are also filed, Annexer 7 and Annexer 8. Rejoinder affidavit filed by the petitioner to the counter affidavit filed by opposite party number 3.
It's not with me.
Mahesh Kumar Pradhan.
Yes, Manas Kumar.
Manas Kumar Pradhan.
Manas.
It's not with, he has not.
That's why I say that
it is not with him nor with me.
KK Mishra has done.
Yes, I had filed. I had filed, but I don't recollect exactly.
On each page.
What is, pardon?
Mr. KK Mishra, advocate, has filed, signed on each page.
Each page is. That is the usual practice, as your lordship knows.
That's why I said.
Yeah, I don't recollect exactly what was the stand taken. That's why I was seeking for time. Otherwise, it will be misleading. If I say anything contrary to record.
In the writ petition.
No, in the writ petition, which one? The writ petition, and then in the writ petition.
It is there. In the first case, it is stopped. In the first case. Computer page, this digital page 142.
Oh, yes. There are 6 pages that contract with Manas Kumar Pradhan.
Genealogy is confused.
They disputed for the first time in the genealogy in the High Court. I am not the successor. That is not correct.
That is also another factual ground which I will praise. That the
Scope and ambit of Rule 34 has to be seen.
Anybody can
Registration
come
Act.
for registration.
Rule
Even if
34.
imposter, we have to take care of that. They are not at all these legal heirs of the original intermediary.
Sub-register took 24 days to finalize the registration. Registration was completed on 24. It started in 5th January.
No, did you dispose in, did you dispute this position that?
Because I say that he is I know the rule of law, my lord. Even if I get a registered, I can't get the property. I have to, because my consistent stand, my lord.
Our question is something else.
I have disputed that, but I have not gone through the.
Para 17 has not
gone through, then why are you arguing?
Mr. Mishra, my lord is asking some other.
They have suppressed the fact before the law, a single judge, and have committed a serious fraud for getting favorable order. My lord, the land in question is situated within the reserve waterworks area of the coastal city of Puri. From Oya to the reserve of Puri town.
Mr. My lord wants answer on a query which Mr. Mishra is to answer. Please.
My lord, this is a very small.
Please have patience to.
Very small region. So far as that part is concerned, which my lord is asking, para 17 of my counter with regard to non-gender, the entire rejoinder I have just have I have already noted. There is no reply to that.
Yes, you want to argue tomorrow?
In pass. Huh? Pass order. If I have not.
It is not at all. I have entire. Your lordship can read.
And then necessary particular, and it is not taken care of by honorable single judge. Your lordship may pass.
I mean, pardon my lord. In Annexure 6 to my read
But my lord, kindly bear with me for a moment, my lord. That I have stated specifically, he was my lessee, my lord. He is my caretaker. He was taking care of, taking advantage of the situation. On my absence, he managed to get a lease deed in showing that it is that property. And civil court has disputed that it doesn't belong to that particular property. What he claims, my land senior, my lord. Kindly, I would like to only draw your lordship's attention one paragraph of the honorable civil judge who was disputed his title.
Would annexure?
Yes, annexure the 730.
Those aspects we cannot go into.
That is also not there in the rejoinder.
That's why, my lord, that prompted me not to make him a party, my lord. Because of civil judge order, that is relevant.
So earlier you had wrongly made him party.
No, earlier, my lord, I say that he is in possession of the property, but in fact, I am the owner by virtue of the Supreme Court judgment. It should be registered keeping in mind the judgment of the apex.
He is in possession since when?
My lord, he is claiming that he is in possession since 86.
1923.
I say that he is in possession as my caretaker, my lord. He says that 23, but that document doesn't relate to my property, my lord. He is only with respect to 500 decisions.
Annexure 6 is
and
civil court judgment
and single judge, learned single judge has held that it is the property doesn't belong to him. No title was conferred. And to another suit is also pending. Suit is pending.
We will decide on that simple. We may remand the matter back.
Item 51.
You are also asking another pertinent question, whether in 1953, my vendor's predecessor had approached for this property that I have brought. You will also on technical ground reminding it.
Technical ground.
Yes, my lord, I need not disclose it, my lord. It is with me. But registration is completed, I got to only, I have to take the registration document.
Filed affidavit, nothing has been completed.
Once the matter is remanded back, you will have a very right to. Yes,
That Gantinate matters. That Gantinate matter
Yes,
also was
yes,
hearing
yes.
yesterday.
Yes.
Your number was
No, the app-
263.
No, my case is WPC 34769 of 2020. 34769 of 2020. I am appearing that case. Other
Page-
councils are there
page
in other
16.
cases. But so far as I am concerned, Lord, I am raising this. Now, after in course of hearing yesterday, my lord,
Page 16. First piece. Yes. 3, 4.
Yeah, this is-
769.
Yes.
Lord, I just draw your lordship's attention to certain statutory provision which I have already placed. But for the purpose of my submission today, I just want your lordship to take, because I know that your lordship, that judgment of Anup Senapati which stands in the way. That is what, so I am trying my best at least to convince your lordship that how I can avert that judgment of Anup Senapati in this case, and to what extent that judgment can be applicable. And you also look again to section 7C. Two provisions I am referring to under the Orissa Education Act, the substantive one.
Yes.
7C, I have already placed 7C1. The state government shall within the limits of economic capacity set apart a sum of money annually for being given as a grantee net to private educational institution. Let's kindly have a glance again, because 7C1.
Yes.
The state government shall, within its limits of economic capacity, set apart a sum of money annually for being given as grantee net to private educational institution. Then kindly look to Sir 4. Skip over 2 and 3, 4. Notwithstanding, non-obstantly clause, notwithstanding anything contained in any law, rule, executive order, or any judgment, decree, or order, any court, no grantee net shall be paid and no payment towards salary cost or any other expenses shall be made to any private educational institution or for any post or to any person employed in such institution after the commencement of the Orissa Education Amendment Act 1994, except in accordance with an order or rule made under this act. Grantee net, where admissible under the said rule or order, as the case may be, shall be payable from such date as may be specified in that rule or order, or from such other date as may be determined by the state government. If I am not correct in the interpretation of section 7C, 7C required the state government shall is a mandatory within the limits of economic capacity, set apart some money annually for being given as a grantee to private education institution. 7.4 says that any order or rule has to be framed in terms of section 7C4 for payment of grantee that shall be payable from such date as will be specified by the state government. That is what. Now, in terms of section 7C4, your Lordship has seen that 94 grantee order was enacted. In the preamble is in exercise of the power under section 7C4, the grantee order 94 was enacted, which will govern both the educational institution as well as the employees and the post. There is no dispute about this. Now, at this juncture, because my first argument would be, you'll also look to section 24, page 159, section 24B, because I have read it time and again, which comes to my mind, I must convey to your lordships. This is my first argument. Adjudication by tribunal. Lordship, get it? This was also incorporated by your amendment. Where after this section 7C4 was incorporated, this 24B was also incorporated in 1998. The tribunal shall, tribunal shall have jurisdiction, power, and authority to adjudicate all disputes and differences between the managing committee or, as the case may be, the governing body of any private educational institution and any teacher or employee of such institution or the state government or any officer authority of the state government relating to or connected with the eligibility, entitlement, payment or non-payment of grantee. Then 2, any person aggrieved by an order pertaining to any matter within the jurisdiction of the tribunal may make an application to the tribunal for redressal of the grievance. Then 3, on receipt of an application under subsection 2, tribunal shall, if satisfied after such inquiry as it deemed necessary, that the application is fit for adjudication, by it admit such application, but where the tribunal is not so satisfied, it may summarily reject the application after recording reason, provided you also skip over. Then you also kindly come to 24C. A power of appeal is also provided by the under the statute to the Honorable High, to the this Honorable Court, 24C. Thus, that was also incorporated by Act of 5 of 1998. Appeal to High Court. Any person aggrieved by an order or decision or judgment of the tribunal may prefer an appeal before the High Court within a period of 60 days from the date of such order or decision of judgment. So there is a right of appeal against the order of the tribunal, and tribunal is authorized under the Act to adjudicate the matters, and that is subject to the appeal provided under the statute, under the Act. Now, so far as the petitioner case is concerned, I have already placed that date chart, you have seen it. In 96, much prior to 2004, when the impugned repeal provision was incorporated in 2004, 96 petitioners approached this Honorable Court because the governing body had submitted the proposal in 1996, but so far as other candidates are concerned, action was taken. In case of the petitioner, some reason or other that was not taken to approach this Honorable Court 96. And while that matter was pending before this Honorable Court in 2004, now the repeal provision was provided. Now my submission is the adjudication power conferred under the statute, that is by substantive provision section 24B, must be read with section 7C and 7C4. If adjudication relating to release of the in connection with the grantee under 94 grantee order was pending for consideration, can the legislatures, can the state, I can say the state, by making a provision incorporating Rule 4 under the grantee order 2004, can they take away my rights? Whether my right of adjudication, to make a prayer before the tribunal, to make an adjudication of my right in terms of 94 grantee order, whether that such a right can at all be taken away. So far as that Rule 4 is concerned, that is my submissions. So far as that Anup Senapati's case is concerned, that is a case, my learned friends can argue that also, that was a case which arisen out of an order which was filed much after 2004, not earlier to 2004. That was a case arising out of an application which was made subsequent to 2004. But my application was much prior to 2004. So my first point of contention raised before Lordship is, right of adjudication is there in terms of section 24B. That is the act itself. And now the 2004 granted order that is pursuant to section 7C4. Now section 7C1 read with 7C4, read with section 24B 1, 2, and 24C. That means my argument is the adjudication right of decision is otherwise. Decision maybe later, or my right of adjudication before the tribunal cannot be taken away by Rule 4. That is my. So therefore, Rule 4 protecting only a class of employee, those who have already got it, but a person like us for whom the adjudication is pending before the tribunal, that cannot be taken away. We are creating a class amongst the class by incorporating the provision of section 4.1.
So your matters are pending before the tribunal?
Yes, sir. That matter was pending before this Honorable Court. Even after 2004, if you also look to the date chart, this Honorable Court transferred the matter to the tribunal, because while the matter was pending before this Honorable Court, the tribunal 24B was incorporated in 2004. My matter was pending here in 1996. So therefore, this Honorable Court transferred this matter to the tribunal for adjudication. And the tribunal, after adjudication in 2014, decided in my favor to extend the gratuity in my favor. So that is my first point. The second point, you also rightly pointed out, you also posed that question to me. I also is required to answer to your lordships. So for the judgment, till the judgment was pronounced in 2019 in Anup Senapati's case, they might have extended, just now the Learned Advocate General was arguing in other cases, that we have extended the benefit to 2019. But the moment the judgment was pronounced in Anup Senapati's case, we have stopped it. But that is not a case they have given, that's another part. But the question comes for a consideration, as your lordship, yesterday I have cited before lordships, that one judgment, that Profulus House case. In Profulus House case, the question which was for consideration, section 7C4 and the grantee order 94 and the object of 94 grantee order, whether the state, it is a mandatory provision under section 7C1 to make a provision in the budget every year. Only they can fix the date when they are entitled to get, but that is the question for consideration in Profulus House case. That judgment was challenged by the state before the Supreme Court. And the Supreme Court, the SLP was granted, the civil appeal was decided in 2010. And your lordship knows that once a civil appeal has been dismissed, I brought those judgment, your lordship must have known those, the principle of merger in a case of SLP having dismissed, principle of merger will not apply. But in case of civil appeal, if the civil appeal has been dismissed and the judgment has been upheld, then that became the law of the land under section 41. That is I'll show you that judgment you also must have seen. That became the law of the land. But that Profulus House case judgment not only implemented in the Chittaranjan Parida's case, which was way back in 2011, in 214 degree colleges and 41 plus 2 colleges, admittedly, Miller, extending the benefit of 94 grantee order, notwithstanding the provision of the repeal. And in terms of the judgment in Profulus House case, Chittaranjan Das case, yesterday I have placed before lordship, there also the question of 4.1 was raised, repeal provision was raised. And subsequently, because at the instance of the state, they say that financial crunch and all these things, whether the judgment rendered in Profulus House case is a correct law or not, it was referred to a full bench. That's why look to that judgment. Why I am citing so? But if there are two judgments of the coordinate bench of the Honorable Apex Court, that is the judgment passed by the Profulus House case, that has not been taken into consideration the judgment in Anup Senapati's case. Sir, I have brought it.
No. You see, when there are two judgments,
yes, sir,
of bench of equal strength,
right, sir,
then it is the duty of the High Court,
yes, sir,
to see which judgment shall apply in that case.
No, sir. Here,
sir.
I do. I'm just citing a judgment of 2023 Supreme Court.
That is not the principle. The principle is
There, and there.
that in the later years, not conflicting, if there are two decisions
Yes, sir.
taking different views,
Yes.
then it is the duty of the High Court to reconcile those decisions.
Sir, with respect, also look to that judgment, recent judgment of 2023, whether it also have an occasion to go through the judgment, paragraph 35. Paragraph, that judgment, Union of Territory Ladakh versus Jammu and Kashmir, 2023 IN Supreme Court 804, will also come to page mark, page 35, paragraph 35. Yes, page 18, page marked. We are sorry. Page marking.
Yes.
Yes, sir. Let's get it, page 30, paragraph 35.
Yes.
Yes. We are seeing before us judgment and orders by High Court not deciding cases on the ground that leading judgment of this court on the subject is either referred to larger bench or a review petition relating thereto is pending. We have also come across examples of High Court refusing deference to judgment of this court and the score that a latter coordinate bench has doubted its correctness. In this regard, we lay down the position of law. We make it absolutely clear that High Court will proceed to decide matters on the basis of the law as it stands. It is not open unless specifically directed by this court to await an outcome of a reference or a review petition, as the case may be. It is also not open to High Court to refuse to follow a judgment by stating that it has been doubted by a latter coordinate bench. In any case, this line, in any case, when faced with conflicting judgment by benches of equal strength of this court, it is the earlier one which is to be followed by the High Court, as held by a 5-judge bench in National Insurance Company versus so-and-so 2017-16 SEC versus so-and-so. The High Courts, of course, will also do careful regard to the facts of
This is a larger bench. If there are two decisions,
Yes,
one of the larger bench and the other of
Here is a case of, again look to that. It is,
see,
I'm reading it again, sir. In any case, when faced with conflicting judgment by benches of equal strength
yes,
of this court,
yes,
it is the earlier on one which is to be followed by the High Courts, as held by the 5-judge bench in National Insurance Company Limited versus so-and-so. That judgment also I brought it. So that is a constitutional bench judgment. That is at page
Paragraph number 29 and 30.
That is at page 5. Start from page 24.
no, it's very difficult, Mr. This will have the consequence of holding subsequent decision of the Supreme Court per incurium.
So that is what.
Can that be done?
But the only sir question is.
And there are decisions. You can find out there are decisions that when there is some conflict between two decisions of equal strength, then first of all it is the duty of the High Court to reconcile, which case is more applicable. And secondly, if the subsequent decision considers the earlier decision, then second decision.
That is right. If the subsequent judgment has taken note of the earlier judgment,
But if we take this view that we shall follow the earlier decision and not the later decision, then it will amount to holding the subsequent decision per incurium, which is impermissible for the High Court.
This is 2023.
We will examine. We will
Sir,
see.
If you also will say, well, again examine. I have to.
There are
the tax to my land. Yes, I'll examine further. So far this aspect is concerned, it is a very, according to me, Lord, if the judgment in Professor's House case, if your Lordship will say that that is for the High Court to say to make all attempt to reconcile. If it will not be reconciled,
If it is not reconciled, the law is that the High Court shall make endeavor to reconcile, one, and two, if it is not possible to reconcile, then take that approach which befits most in the facts and circumstances of that case. This is the law.
If your lordship, I know, Lord, that this is the judgment after seeing this judgment, which has been in the constitutional bench judgment, 5 judges.
You are right. 5 judges judgment.
So I can't so formally I can go through again all the judgment on these aspects. Certainly because I can't say so boldly that your lordship is bound by this. But this is what I've studied, that if the earlier judgment has not been referred to the latter judgment, but I was under the impression it is only the Supreme Court will say. But the High Court, here it is said in that constitutional bench judgment, and here also, the High Court will say if the bench strength is same and there are 2 conflicting views, that the earlier view must be taken to the consideration. That is what they have said. But I'll examine. If philosophy will permit me, I'll examine those points. The constitutional bench judgment at page 34, paragraph 30. I've also given the same thing has been said, relying on another judgment of 2014 Supreme Court. Paragraph 30.
Do you have that
Yes.
5 judges?
Yes, sir, that I've given to your lordships. That starts with page 24. Relevant portion is at page 34, paragraph 30. 29 and 30. Just let me read now.
Page?
Page 34. A page marked in ink. Page 34. Running page 34. That judgment starts from page 24. National Insurance Company Limited versus so and so.
Which paragraph? Which page?
Page 34.
Yes.
Para 29. We are compelled to state here that so and so supra, the 3-judge bench should have guided by the principles stated in Resma Kumari, which has concurred with the view expressed in Sarada Devi. And in case of disagreement, it should have been well advised to refer the case to a larger bench. We say so, as we have already expressed.
This is for the Supreme Court.
The Supreme Court, yes, sir.
This is not for the
Yes,
High
sir.
Court.
Yes, sir. Yes, I agree.
That principle has been applied.
That's right. But para 30 also look. In this context, we may also refer to such and such cases which correctly lays down the principle that discipline demanded by a precedent or the disqualification or diminution of a decision on the application of the per inquirium rule is of great importance, since without it, certainty of law, consistency of ruling and committee of courts would become a costly casualty. A decision or a judgment can be per inquirium, any provision in a statute, rule or regulation, which was not brought to the notice of the court. A decision or a judgment can also be per inquirium if it is not possible to reconcile its ratio with that of a previously pronounced judgment of a co-equal larger bench. There can be no scintilla of doubt that an earlier decision of the co-equal bench binds the bench of the same strength. Though the judgment in Rajesh case was delivered on a later date, it had not apprised itself of the law stated in so and so, but had been guided by Santosh Dabi. We have no hesitation that is not.
This is for Supreme Court.
This paragraph 30.
Yes.
That you also may read it in paragraph that 2023 judgment.
We are reading 2023.
Right, sir.
This is what the observation made by the 5 judges.
Yes, sir.
Is for the Supreme Court. When the Supreme Court faces such questions, then how the Supreme Court will proceed?
Right, sir. Right.
The law lays down.
But if you also look again to that part 23, that in fact I was
You are right. You are right. This is therefore we wanted to see what is there in 5 judges. Whether that is the.
This is also a judgment of the Supreme Court.
Yes.
So far the High Court is concerned, they have referred the word High Court. What is the duty of the High Court to see the judgment of the co-equal bench past orders? And
we will surely consider that decision.
Yes, sir. So, sir, I have prepared a short note for your lordships in this. Let me copy data. This is my submission so far as the entire case is concerned. Your friend. Yes, sir. 2-3 points I have developed for your lordship's appreciation. The judgments passed by the this Honorable Court in case of Prafulla Kumar Sahu versus State of Orissa and others, OJC number 126 of Swanso, which was subsequently been upheld by the Honorable Apex Court in Civil Appeal number 385 of 2006, by order dated 10/8/2010. Therefore, applying the principle of doctrine of merger, the judgment of this Honorable Court has become the judgment of the Honorable Apex Court. The only question for interpretation is that where the earlier judgment passed in case of Prafulla Kumar Sahu, being the earlier judgment, the same has not been referred to the bench of equal strength while deciding the case of Anup Kumar Senapati Supra. Therefore, under these circumstances, the judgment of Prafulla Kumar Sahu must prevail. That is my first submission. Then two.
In Prafulla Kumar Sahu case, the lordships have upheld this court's judgment on facts or laying down any law.
Laying down the law. So far, Supreme Court said we are not in civil appeal. That was converted to civil appeal. Then the finding is that we are not inclined to entertain the civil appeal. It's dismissed, and we are directed to also look to that order. That order that is I have given to us yesterday. On judgment, and before that, I must place the order passed in the civil appeal of the Prafulla Kumar Sahu's case. And given to lordship, just I'm reading one paragraph only that judgment. We have heard civil appeal number so and so. We have heard Lord Counsel for the parties. Application for intervention are allowed. We have carefully gone through the impugned judgment passed by the division bench of the High Court of Orissa. In our considered view, no interference is called for. Those appeals are devoid of any merit. We, however, direct the appellant to decide the case of the respondent as expeditiously as possible in any event within 4 months from such. At this juncture, even where a civil appeal has been dismissed without giving any reasons, hard dismiss, what will be the law? You also kindly look to page 45, the bunch I have given to yourselves. Page 45 today I have given to yourselves. Today's that bunch that reported in 2019. For SEC page 376. Page 45. Page 45
of the today's bunch.
My bunch.
Page. Achha.
Coded distillery.
Yes, sir. Yes.
They have followed Kuni Ahmad.
Yes, Kuni Ahmad. Yes. You also look to page 56.
Yes.
Page 56. To sum up our conclusions are, page 44, paragraph 44. To sum up our conclusions are, where an appeal or revision is provided against an order passed by a court or tribunal, any authority before superior forum, such forum shall modify, reverse, or affirm the decision put in issue before it. The decision of the subordinate forum merges in the decision by the superior forum, and it is latter which subsists, remains operative and capable of enforcement in the eye of law. You also kindly look to Roman 6. Roman 6. I am concerned with that. I will not take your lordship. Page 57. Roman 6. Once leave to appeal has been granted. Let's get it.
Yes, sir.
Once leave to appeal has been granted and appellate jurisdiction of the Supreme Court has been invoked, the order passed in appeal would attract the doctrine of merger. The order may be of reversal, modification, or merely affirmation.
Merger is a different thing.
Sir, why sir,
They are not disputing this, this
sir,
proposition.
sir. Why
This is
I'm citing this judgment, sir? Because the judgment passed in
We
proper.
understand that. That's that.
Sir, here, I only want judgment of this court where the correctness of the judgment of Profullus House case was decided in 2014. That's why look to that. Kindly have a glance at that. That I have given yesterday to your lordships that. Your lordship, kindly have a glance to the yesterday bunch. The judgment I have given. I was citing those judgment, that is at page 23. Yesterday, my lord. Yesterday that.
Yes.
Also, see, this judgment was delivered on 14th May 2014 by a larger bench, by the full bench. Reported in AR 2014, Orissa, page 116. The reference, just I'm reading one paragraph, then I'll take to the operative portion of your judgment. This reference has been made by a division bench of this court to the full bench for an authoritative pronouncement of the scope of ambit of section 7C of the Orissa Education Act 1969, herein after referred to as Act, the interplay of section 7C1 and section 7C4 of the Act, and the granting order promulgated in terms of section 7C4 of the Act, vis-a-vis the jurisdiction of the court under Article 226 of the Constitution to direct the government for making necessary budgetary allocation for payment of granting aid. You also just have a glance to the last operative portion of the judgment. That is at page 39. Various judgments have been referred to by the full bench. Page 39. Para 28. In our view, let's get it. In our view, the judgment in Profulla Kumar's house case is perfectly in consonance with the law laid down by the apex court in the decision cited supra. We do not find any valid reason to take a fresh look into the matter. The reference is accordingly answered. The registry is directed to place the matter to so and so. So the judgment in Profulla's house case became the law of the land after the dismissal of the civil appeal, and that has been subsequently referred by this court also to a larger bench, and the full bench decided that the law decided in Profulla's house case must hold the field. And accordingly, so far as the lecturers of my college which I am arguing before lordship, all have got it under 1994 granted on the self-same proposal. But so far as petitioner is concerned, because that is some reason or other that was kept pending before the authority. In the meantime, 2004 granted order came into force. But in the meantime, I have already approached the tribunal in 96, before this honorable court. And this honorable court transferred the matter to the tribunal, and tribunal adjudicated the matter in terms of section 24B. And the state appellant has preferred an appeal against that judgment under section 24C, which is pending. So now at this stage, and they have taken the stand only that Anup Senapati and that repeal provision, nothing else. So therefore, my respectful submission is, so far as these coordinate bench judgment of Profulla House and Anup Senapati, that your lordship already, whatever I have explained to your lordship, I need not place it again. But only one thing I'll show your lordship. I was placing my note, the second argument, which has paragraph 2. Paragraph 2.
Yes.
Section 24B of the Orissa Education Act, being a substantive provision.
No, this is first note or second note?
Today's note.
Yes, paragraph second, whether there is any reasonable nexus.
No, that was the earlier one.
Earlier
After this, that today I have given a note. 3 pages note. 3 pages.
There.
Yes, that's right.
Judgment passed by.
Yes, sir.
Yes.
I have already placed paragraph 1, paragraph 2.
Yes.
Section 24 capital B of the Orissa Education Act, being a substantive provision conferring power upon the State Education Tribunal to adjudicate the dispute relating to or connected with the eligibility, entitlement, payment or non-payment of granting aid. And after adjudication, the learned tribunal directed for release of granting aid under Granting Order 94. Therefore, Rule 4 of 2004 Granting Order, being a subordinate legislation, cannot take away the right of the petitioner which has been accrued pursuant to the Granting Order 1994. Then 3. Since the correctness of the judgment rendered by the division bench of the Honorable Court in case of Profulla Kumar Sahu The same has been considered by the full bench of this honorable court in case of Arun Kumar Swain and another versus State of Orissa, reported in year 2014, Orissa Swanso, in the context of Rule 4 of 2004 granted order. And in view of the full bench of the honorable court, the law decided in case of Prafulla Kumar Sahu is a correct propositional law, which has been carried out by the state authority throughout the state, and therefore there cannot be any discrimination vis-a-vis the entitlement of the present petitioner applying the repeal provision under 2004 granted order. Para 4, next page. The judgment rendered by the Honorable Appeals Court in the case of Anup Kumar Senapati Supra was rendered by the Honorable Appeals Court was in the year 2019, was a case where the claim was made after 2004 granted order came into force. And whereas the claim of the present petitioner vis-a-vis the grantee is relating to the year 1996, which has been adjudicated in favor of the present petitioner by the London State Education Tribunal under Section 24B of the Orissa Education Act, by its order dated 1/2/2018. Therefore, the effect of the repeal provision of 2004 cannot take away the right of the petitioner accrued by virtue of the judgment passed by the London Tribunal. Even I can go to the extent for accrued for the purpose of adjudication. Even judgment is secondary thing, adjudication. Then para 5. The institution of the petitioner has been notified under 94 granted order, and the other staff of the institution in question who are admittedly junior to the present petitioner are receiving the benefit of granted in terms of 94 granted order. And because of the delay caused by the government in acting upon the proposal submitted by the governing body, which was submitted much prior to 2004 granted order came into force, in terms of 94 granted order, the present petitioner cannot be denied the benefit of 94 granted order, taking the plea of the repeal provision of 2004 granted order. Then the last but one, while the impugned provision, next page, while the impugned provision of Rule 4 of 2004 granted order protected the person, if you also read that provision, you also will see, Rule 4 protected the person who were already in receipt of 94 granted order, whereas the person like the present petitioner, in whose paper the proposal was pending prior to 2004 granted order, it came into force, were not protected, and thereby the impugned repeal provision is discriminatory and violatory Article 14. Then 7. Different benches of this honorable court, while deciding the issue, of course, single judges, that judgment has not been challenged as yet. Different benches of the honorable court, while deciding the issue of entitlement and right of person under the Validation Act 1998, have clearly directed the state authority to release the grantee in their favor in terms of 94 granted order. Those judgments have been passed recently. Even after the pronouncement of the judicial pronouncement passed in the case of Anup Kumar Senapati, even the Honorable Appeals Court, after the pronouncement of Anup Senapati, has directed the state government to release the benefit of grantee under the granted order 94 to the teaching and non-teaching staff of different institutions. Sir, this is my entire argument. Only one order of the Supreme Court I can show you, Lordship, before I close my argument.
Yes.
Your Lordship, kindly look to that yesterday's bunch where I was placing that full bench judgment, that page 41. Page 41. Let's get it.
41.
Yes, sir. Page 41.
Yes, just come.
That Supreme Court SLP number, so and so, let's get it. Yesterday, that bunch I have given to you. Yesterday bunch. Sorry, madam. I should prepare a paper book.
41, yes.
Yes. You also see, one SLP was filed. All these intervention applications, clarification application, and interim applications are filed by different colleges, different employees. And you also kindly come to the order portion, what the Supreme Court has said. And the judgment was passed on 8/12/2017. Let's come to page 46. These matters were called for hearing today, that is on 8/12/2017. And the order, if your Lordship will come to page 47, state was the petitioner before the Supreme Court. And state's entire case was that repealing provisions. We do not find any reasons to entertain these special leave petitions, which are accordingly dismissed. Let's get it at page 47. And you also look to that bottom of that page, one paragraph from the bottom. It is open to the interveners to lay their claim under the Granted Order 94, also as may permissible in accordance with the law. And so far as 94 Granted is concerned, even 2017, the Supreme Court said that they can proceed, and they have pursued, and they have got the Granted Order 94 Granted Order. So this is my case. My grandparents are there. They can argue the matter. If
anything else to be added?
Sorry.
I don't think there is much left to be said here in this matter. Almost all the points are covered, but then if Lordship permits, I can supplement by 2 to 3 points only.
Yes.
Without, of course.
Yes, no. Why should we? Rather than may benefit us.
That I have also prepared for my Lord's convenience a small note. That I am conscious we are standing on a slippery ground. In the teeth of Anup Senapati, unless
the only difficulty I must tell you that it's a big this thing obstruction. Very difficult to overcome that.
Get over Anup Senapati.
Overcome that situation that we declare the order itself to be ultra virus, and the effect of which shall be
Anup Senapati will be taken out.
Anup Senapati goes.
But that I'll try to save Anup Senapati and save this case also. That's my whole endeavor. Without touching Anup Senapati, if we can get over Anup Senapati saying that...
No, you will have to touch Anup Senapati because you are challenging an order based on which that decision has been...
But to get out from this proposition of not touching Anup Senapati, I was trying to convince my lords, if at all I can persuade my lords that a judgment is not a law by itself. It's a law on its own facts. That proposition I did not cite judgment before my lords. If a lordship sees what is Anup Senapati, I think till time, lords may kindly see 4 paragraphs from Anup Senapati. Of course, I don't know if any other council has placed it or not. Kindly see 4 paragraphs from Anup Senapati. Paragraph 24, 25 and 26 of my note, page 27. Today's note.
This is a submission that should have generally 200 pages or what?
I'll try to persuade my lords. I know it's very difficult task, but then...
No, not a difficult task for us. No,
it's difficult for us, my lord. It's difficult for us.
Yes.
Lordship, see page 27.
Yes.
Para 24 deals with those modalities of a non-government educational institution eligible to be and desirous of obtaining notified as added institution has to apply in form. This is a procedure which your lordship has read it from 94 Granted Order, para 4 and 5. Lord, skip over 24, then 25. It is crystal clear from the scheme of 1994 order that granting aid has to be claimed within a period prescribed and director on good and sufficient cause shown may extend the period. Otherwise, it cannot be claimed. Even after completion of 5 years and 3 years period, as the case may be, there is no automatic accrual of right for receiving granting aid. It is dependent upon opinion of the director which education institution shall be the best to cater to the need of the area. Then 26 is important, but I'll emphasize on this.
Yes.
I am emphasizing on para 26, lords may kindly say. The employees have filed representations to claim granting aid under 94 order, belatedly for the first time in the year 2011-12. That too, according to the directions of the Honorable High Court, which were rejected. Thereafter, they approached the tribunal by filing original applications, whereas on the completion of qualifying period, the institution has to inform the director to claim granting aid. There is no material on record that the institutions have duly applied in the particular academic year and within the time fixed for making application in 94 order. And there is nothing on record indicating that requisite information was furnished. No such supporting document have been placed on record. Be that as it may, Fact remains that there is no order placed on record whether such prayer, if any, made by the institution has been rejected as per 94 granting aid order. The representations which have been placed on record are of 2011-12. As the granting aid is annual, dependent upon economic limits and financial viability of the state government, it was too late in the day to file original application or writ petitions in the year 2010 to 11-12, claiming the benefit of granting aid order 1994 order. In case employees institutions are desirous of obtaining granting aid order 94 order, they ought to have taken steps within reasonable time in view of the fact that it cannot be claimed as a matter of right, but it depends upon annual budget and fulfillment of various factors as contained in the previous provisions of 1994 order. So, what Anup Senapati was dealing with those category of specific applicants, those who applied in the
Council, had you based on your prayer within the ambit of 94 or 2004, the matter would have been different. But you are challenging the validity of the order.
That I'll come later on. That I'll come later on. Lord, I have made little endeavor to satisfy my lords and touch that point. Why I am challenging 2004 repeal provision? Why?
That cannot be done because the Supreme Court has dealt with that aspect.
Yes, your lordship has rightly distinguished that. Rightly said, clearly two types. One is my entitlement. Other is challenge to the repeal provision. There are clearly two aspects involved here. If your lordship sees Anup Senapati's case, Anup Senapati is also divided into two parts. The entire judgment is divided into two parts. One is part dealing with those applicants who have repealing provision qua section 5 of Odisha General Clause Act, which is section 6 of Central General Clause Act. But I'll try to satisfy my lords on that very specific point. That's obviously a genuine question.
Cannot be gone into because the Supreme Court has dealt with that aspect.
Honorable Supreme Court has said that, referring to these facts, that no right has accrued in your favor to claim granting aid since the repeal provision has come into operation in the meantime. So your lordship is to see.
That issue has been set at rest.
That your lordship is to see from our facts whether right had accrued in our favor or not.
Mister, just imagine a situation when we hold the order, the 2004 order to be ultra virus, and what will happen to Senapati? This is what we are saying.
That is why I am saying, my lord, I am trying to wriggle out of Anup Senapati's ratio.
Difficult. Either we will uphold 2004,
right,
or we shall hold that to be ultra virus. There are only two aspects.
But there is a third aspect. Lord.
What?
Lord, referring to facts of each case, if your lordship finds that we have a right, and we are not affected by repeal provision, that your lordship will consider. That your lordship will, that is my whole endeavor to place before my lordship. Lord, so as your lordship has rightly got those two, and the third I am just trying to supplement to my lordship.
Third cannot be decided by division bench.
So keeping that issue, while deciding these matters, if your lordship can keep that issue open, we can raise it before the single judge. We can raise it before the single judge. But that's a point, my lord, your lordship should consider that. Because otherwise, what happens, my lord? Lord, looking at the facts of all these cases, I'll try to convince my lords that we had in fact a right.
That I have seen, no? Yes, I have seen. They have discussed everything.
They are not happy with
All right, we will see.
Lordship is closing it today, man.
Yes.
Lord, I am trying to I am just trying to show one or two more judgments, man.
Sure.
Right. Lord, I have placed para 26, Lord. Now your lordship may see from Anup Senapati, my lord. That repealing provision I must also show to my lords, where the Anup Senapati has held. In what context the Anup Senapati has said that rights are closed. Lordship may kindly see that paragraph. Para 34. Lord, I'll be taking.
We have time. We have enough time. We need to conclude it because we are hearing this matter for so many days.
Right. I also want to conclude it. Lord.
Yes,
kindly see page 30. Page 30.
We have to keep in mind the welfare of poor litigants also.
Lord, so grateful, my lord. So grateful. So grateful. These are the. That's right. Justice-oriented approach, Lord. So grateful to my lord. Lord, para 34, page 34 of my note, my lord, if your lordship sees that in the present case, it is apparent that there is no absolute right conferred under 94 order. The investigation was necessary as to for whether granting was to be released or not. It was merely hope and expectation to obtain the release of granting which doesn't survive after repeal of the provisions of 94 order. But the Supreme Court, in the context of the fact of this case, is saying that these people have never applied, their college has never applied, their managing committee had never applied. For the first time after repeal, they are coming forward to claim it. So that is in that context, on the Supreme Court is saying that no right has accrued in your favor. And in that context, the General Clause Act was taken short of and saying that it doesn't save your right. That saving clause doesn't save our right because Section 6 and 5, Section 5 of Odisha Act and 6 of Central Act doesn't come to our help. If your lordship sees, what is the fact of our case? 94 order came into force. Governing body of our college immediately thereafter has submitted proposal for grant of release in favor of its staff who are eligible, appointed following the process of law. But that list included our name. It was given in the year 95, 96, 97. But the government, while considering that proposal, as my learned senior was submitting, release in favor of a part of those lists. So far as we are concerned, it was never rejected. So if it would have been rejected, certainly I have no claim. It was never rejected. It was kept pending. Now, 98, I approached my lords, this honorable court. And this honorable court relegated me back to the tribunal after its constitution in the year 2000. So, that the Begraj Singh I was citing in other case, my lord, rights of the parties stands crystallized as on the day I approached the portals of the court. Here, I have approached the portals of the court in 1998. My application was pending before the government. Even till date, it is never rejected. It is never rejected, man. So that is why the peculiarity in our matter, we say that we are factually distinguished. We are to be considered as a class of ours, and even assuming whether in these facts we can be considered under 94 order, if your lordship keeps it open to be decided by the single judge as a third point, that will be doing a great justice to these people. My lord, and one more point, I'll be just citing Professor Sahu, my lord, I am not repeating, my lord, I'll not wasting my lord's time. Professor Sahu and other judgments my learned senior has placed. My lord, page 112, page 113 of my note, my lord, I'll be concluding by placing this point.
Yes.
Para 29.
113.
My lord, 113, para 29. This is judgment by Honorable Supreme Court. Service jurisprudence evolved by this court from time to time. Let's got it, man.
Yes, please. Please.
Right. Service jurisprudence evolved by this court from time to time postulates that all persons similarly situated should be treated similarly.
Yes, that is the law.
That is the law. Now, kindly see the list in my case, my lord. In my writ petition, if your lordship sees the list, I was appointed in 89. A person appointed in 88, we are all similarly placed. You are giving the benefit of 94 GI to those 88, 89 persons and not giving me. Lord, and Honorable Supreme Court further says, Lord, kindly see, only because one person has approached the court, that would not mean that persons similarly situated should be treated differently. I'm still standing at a better footing. Here I have approached the court. You have not yet rejected it. So my rights are not closed. If your lordship see the General Clause Act, Odisha Act, my lord, kindly see, my lord. Effect of repeal. Lord, there the effect of repeal was being considered in the context of people, those who have applied later on. No application was pending as on the date of repeal. Here, my lord, where any Odisha Act repeals an enactment hereto made or hereafter to be made, then unless a different intention appears, the repeal shall not be, my lord, 1B. Lordship,
Please.
affect previous operation of an enactment so repealed or anything duly done or suffered thereunder, affect any right, privilege, obligation or liability acquired, accrued or incurred under any enactment so repealed. Lord, here my obligation, the state's obligation is already there in view of the fact that I have applied and it is pending. So the effect of repeal, that's why I said Anup Senapati is to be kept preserved in its own facts. Anup Senapati was not dealing with the cases of our nature.
No.
So grateful.
Yes.
My Lord Mr. Sahu, he has number of cases. You are stating.
No. I have only 2 cases. but because my seniors have already
addressed
the court, my lord. But your lordship put forth the question which also troubles us. And we also, my lord, my humble submission before lordship is, once Anup Senapati, relying upon the 2004 order, has already laid down the law. That's one, taking note of the repeal provision of 2004, that once 94 is repealed, but that is not in existence, no claim under the 94 is entertainable, but only relying upon the 2004 order. My humble submission before lordship, in sequence. But 7C is the enabling provision that came into force to the statute in the year 1994. Prior to that, a set of executive instruction, including 83 executive instruction, was governing the field, prescribing the eligibility criteria of the granting aid. But that being the executive instruction, it was not enforceable in law. And the Lakshindra Pati other full bench judgment of this court, which was holding the field, only in case of discrimination, court was inclined to grant the relief. But in order to, there is no right at all to claim granting it under the executive instruction. That is why the state legislature thought it appropriate to make the provisions of granting aid, eligibility, entitlement to be enforceable in law. They brought the section 7C. But while bringing section 7C, your lordship will appreciate the wisdom of the state legislature. They brought other sections also by virtue of that amendment. Section 5, section 6 and section 7D was incorporated. I made it 2 part. If your lordship will allow me, if your lordship, please. Section 7C was incorporated. You will also place the original the gazette. Your lordship will find section 5 was also incorporated along with the section 7C. What 5 says? 5 and 6 deals with permission and recognition of the institution. Recognition as good, the recognition and recognition subsection of the section 6 deals with the affiliation. That these are all preconditions. Institution or a post belonging to that institution must be permitted under section 5 or recognized under section 6A. Otherwise, you will not be eligible. That is why legislature bring it along with section 7C as a pre-restrictions manner. In order to make the eligibility criteria of granting it or right of the granting it as enforceable in law, or to make a mandate granting it where admissible under the order framed under section 7C4 shall be payable. In order to that, brought this pre-restrictions. What post-restriction? Legislature in its wisdom, section 7D, your lordship kindly turn to. Section 7D, withdrawal of granting it. It is not that once the state government framed a granting it, and in terms of section 7C4, a granting it framed that shall be payable. Section 7D, page 141. May I read, Madam? It is the post restriction.
Yes. Yes.
But section 7D, page book is 141.
Yes.
But it was newly added along with the section 7C. Withdrawal of granting aid. Prescribed authority may withdraw the granting aid of a private educational institution if 1, 2, 3 number of points are given. That is up to the 12. 12 points are given. Just I am drawing one. Percentage of students passing in annual supplementary examination conducted in board, secondary education, council higher secondary education, concerned university as the case may be, fall short of. Half of the percentage of students passing such examination for the entire board or council university as the case may be for 3 consecutive years. But what I want to say, my lord, why I am making attempt, my lord, drawing your lordship's kind attention to appreciate this, that in order to make the granting aid enforceable in law by making a mandate shall be payable. They brought these aspects. 4, 5, this permission, recognition, appellation must have got. And even if one is entitled, it is not permanent. Then also subject to scrutiny. He cannot, once he is entitled, it is not that right forever it is, he will receive the granting aid. Therefore, the section 70 was included.
Yes.
That is why, while delivering the, delegated the power to him granting it, only 20. Bear with for a moment because it has been section 7C. Consciously, my lord, the choosing the word 137, notwithstanding clause, my lord. But subsection 4, notwithstanding anything contained in any law, rule, executive order, or any judgment, decree, or order, any court, no granting aid shall be paid, and no payment towards salary cost or any other expenses shall be made to any private educational institution or for any post or to any person employed in such institution after commencement of the Orissa Education Amendment Act 94. But I'm making a full stop. Thereafter, except in accordance with an order, my lord, kindly, I am drawing your lordships, an order or rule. Order or rule has been given under this, my lord, the same status. Once it is to be framed under the subsection 4. Therefore, the full bench of the, my lord senior has already cited that whether the 94 granting order was a statutory, it is enforceable. Court answered in Prafula Sahu, Chittaranjan Mahapatra, so also the subsequent full bench, it is enforceable because it is framed under the enabling provisions. An order or rule made under this act, full stop. The granting aid, where admissible, under the said rule or order, as the case may be, shall be payable from such date as may be specified in that rule or order. But I am pausing for a moment. In order to make the granting aid to be payable, therefore the legislature thought it appropriate to choose this word, granting aid where admissible under the said rule or order shall be payable from such date as prescribed under that order. But there is another sentence with or. From such date as may be determined by the state government. No power was delegated to the government once granting aid is framed to frame another granting aid in the shape of block grant, to introduce a block grant. Court, legislature thought it appropriate once a set of granting aid is formulated, that is to be added uniformly for all non-government educational institutions. And no change can be done because that is to be considered, that is to be framed, taking into account all these provisions and the economic capacity. 171.
You are also saying that 2004 order should be declared ultra vires.
No, that is why I am drawing that the government exercised the power exceeding which is not vested with the government. My humble submission, while the...
Therefore, if 2004 is to be, if 1994 is to stay, then Anup Senapati is incorrect.
Then, I am coming to Malad. That is the it is our unfortunate situation, Malad. Your Lordship kindly appreciate, which shocks Malad. That the entire, Your Lordship, that question was not raised.
That question can be raised now.
Malad, that is why Malad before Your Lordship, Malad.
No.
All these people.
That question you can raise at appropriate stage. You will have the opportunity.
Malad.
Yes.
But that is why my first submission is, it is in exceeding the, or they have diluted the section 7C and introduced one more sentence.
Exercise which all of you are doing here can do somewhere else also later.
My humble submission is, what it has been done, the block grant, only the fixed quantum of 40% or 100%. But granting it is in a salary with DA and AD. But that departure was made without having the power, if section 7C is seen.
We will.
Malad, I will file a short note, Malad, and other Malad.
Please give. Your case was not today, no? Sir, today is there.
Sir, bring
that matter was to be taken up. Yesterday we had taken up that matter.
Should it be?
Mr. Mishra was arguing from online.
Yes.
That is the matter.
Today should it 75 I told.
Can we take up that matter tomorrow if
Tomorrow
not
we do.
inconvenient? Because it is already 4:30
Tomorrow.
and we have a meeting also at 4:45. Yes, what happened?
Yes, well, I am filing this affidavit, Lordship, that if I am not succeeded in the writ petition.
My lord, I
I'm
got
not
the
met claim.
information from NMC. NMC, I got the information because I immediately at 2 o'clock give a message. Their instruction is, if the candidates have attendance as is required in the theory and practical, we have no objection, they can go for the examination.
Do you have the attendance?
Yes, yes, madam, we have a.
Will you wait for the order to be uploaded or you will allow them?
Lordship, Lordship, please.
So like
upload-
we will try.
Yes,
We'll try.
But you.
I have already.
You.
I can inform, but let him file affidavit for the.
Yes, yes, I.
Is it online?
Where is the order?
Not there.
Oh, shit. This writ petition was taken up on priority basis on 7/5/2024 as the same related to the examination of these petitioners. As we were, same related to third professional MBBS part 2 bracketed supplementary examination, comma, which is going to commence from 10/5/2024.
10.
Full stop. Our attention was drawn. Where is that? The letter written by the dean.
27, also page 27.
Our attention has been drawn to a letter dated 21/3/2024 addressed to the controller of examination, comma, which university?
Deed and there is Jyoti Vihar Sambalpur University, Lordship.
Sambalpur so and so university. Body of which reads as under court conference. So, next. Learned counsel on a request made by this court, learned counsel representing the university and National Medical Council
Commission.
Commission
Yes.
have accepted notices on their behalf. Stop. Learned counsel representing the NMC has submitted based on the instructions which he has received that NMC shall have no objection if the petitioners are allowed to appear for the examination subject to the condition that they fulfill the attendance criteria.
Yes, ma'am.
So stop.
Attendance.
Next.
And practical detail.
Today, an affidavit, an additional affidavit has been filed on behalf of the petitioners, stating therein that if the opposite parties allow them to fill up the forms and appear in the said third professional part 2 supplementary examination 2024 provisionally, comma, pursuant to any interim order passed by this court, comma, they shall not claim any equity if they do not What have you said? If they not succeed in the examination,
Not succeed in the writ petition also. Sorry.
equity, if they do not finally succeed, we also
Make it correct.
keep it vague. All right. Yes.
The 75 will be,
In view of the facts and circumstances, we direct the university controller of examination to take all steps to ensure that the petitioners are allowed to appear in the third professional MBBS Part 2 examination provisionally, subject to final outcome of the present writ application. First off, list this matter on soon after holiday, 26th of June. First off, the court expects that the respondents shall file their counter affidavits in the meanwhile.
Pardon to my lord, item 53.
The compliance certificate and personal appearance of the DG police fire, and it is not reached. So
Is he here?
no, he has just gone because he has some urgent work. But I pray that let it be posted to next week. He has filed the affidavit. He has complied the directions of the court. Cannot be posted to tomorrow. That is what.
Item 53, my.
Just a minute. Item 50. It has been the DGP.
Fire. DG police fire.
DG police bracketed fire was present in the court. So stop. List this matter of.
Compliance affidavit also filed.
He has filed a compliance affidavit in the court,
Yes, that is already online.
online. So stop. List this matter on 1 week. Yes.
Sir, item 53, my lord. There is
I would like to submit before your lords. I am appearing for the petitioner in this case, my lord. If the DG has filed affidavit, a copy of the same may
Please
be
give him. Let a
copy of the same may be given.
Said compliance
So that
affidavit
I
be served
go
on
through
the
it
council
and
for.
I pardon to mention only item 53, my lord, kindly taken up tomorrow. Item 53.
All matters will come tomorrow.
Item
There
59.
is also top of list.
Item 59. That is the matter, your lordship, the qualification regarding this fisheries FTA post. I have prepared a short written note of submission and only 2 judgments of the Honorable Supreme Court squarely covering my case.
We will see tomorrow.
Madam, there is
We
the
will
the item 75,
Lord 59, your lordship has fixed
It
it
will
at
come
2 p.m.
tomorrow.
today.
It will come tomorrow.
but item 75 will be taken 2 o'clock.
Let it come tomorrow. Let us rise.
That 2 o'clock, that my matter.
Tomorrow, please, tomorrow, please make a mention. Otherwise, we would have taken up your matter, but make a mention at 2.
If you not say give a little bit priority, it can be first matter can be taken up.
2 p.m. 2 p.m. it will be
Right.
there.
59 maybe at 2 p.m. also, your lordship.
We don't know.
My lord.